One matter taken tomorrow, my lordship. Petitioner, one matter taken, petitioner borrowing the loan from respondent bank. The e-action is held on last year. Petitioner deposited already 2,50,000. Remaining balance 25 lakhs not deposited and writ petition is dismissed, my lordship. Petitioner is ready to deposit 25 lakhs. Hence kindly consider tomorrow, my lordship.
No, tomorrow may not.
Urgent e-action is confirmed. Otherwise, sale is confirmed. Residential house, my lordship. Petitioner is residing the house. Tomorrow, my lordship.
8.
Tomorrow.
8. Monday.
Urgent is there. Other reconfirmation is residential house. But the police arrest.
Auction is held when?
Union Bank already last year sale is e-action is held there, but not confirmed. Already deposited to 2,50,000. True core 50 lakhs.
Tomorrow.
Much obliged.
My lord, respondent is trying to construct the construction, my lord, by violating the interim order.
It will come in the regular court. Yes.
Kindly, my lords, one medical admission matter, my lords, under sports quota. My lords, the notices are ordered, my lords, the matter is set for hearing. My lords, my contention is that, my lords, I should be placed the list at sale number 1, my lords, under sports quota. But not considered, my lords, no objections are filed, my lords. It is in respect of last year. My lords, if the counseling, my lords, for this year is going to start from Monday. My lords, if this is not considered, no, if the seats are filled up, probably, my lord, that may not serve any purpose, my lords. Now only, in fact, my lords, I have got admission in under payment seat in some other quota only that needs to be adjusted, my lords, towards sports quota.
Monday.
Please.
My lords, we have filed a restoration application, my lords. This is a case where the office, my lords, has dismissed a writ appeal without considering my lords, the office, the council submission, my lords. What has happened in this case, my lords, is that we had an interim order against the impugned judgment, my lords. Now, as soon as this has been dismissed, my lords, because of the non-compliance of the office objection, we have received copy of a caveat petition, my lords. That's of a contempt petition, my lords. That's the urgency, my lords. If it could be kept tomorrow for the restoration application, my lords.
No urgent.
My lords, one
What
more.
is the urgent?
My lords, the urgency is that we have been served with a contempt petition, my lords, against the impugned judgment, against which we had a stay. Now, my lords, because of the dismissal, because of non-consideration of the council submission, my lords, they have immediately filed a contempt, my lords.
So you have to stay.
Yes, my lords, we had already obtained a stay, my lords.
Then where is no urgency?
My lords, it has been, my lords, the office had dismissed the writ appeal because of the non-compliance of office objection. But we had already supplied a council submission and we had already made that point clear, my lords. If the restoration could be heard, my lords.
So you want to move restoration application
Yes, we have already filed, my lords.
for restoration
Yes, my lords.
tomorrow.
My lords,
Please.
one matter. My lords, I'm the auction purchaser, my lords, the learned single judge has set aside the auction. I have deposited 15 crores. In writ appeal, bank has opted an interim order. Resultantly, my lords, I am paying my banker interest of around 8 lakhs per month. I have moved an application for vacating stay. Any date, my lords, lordship's convenience. Because I have paid 15 crores to the bank. That has been now set aside for learned single judge. Now I don't have a property nor the money, but I am paying 8 lakhs per month as an interest to my bank.
16.
Very well. Wait.
My lord, I was the L1 tenderer. The tender got cancelled and then the new fresh tenders are floated, but whereas they increased the financial bar, my lord. So that's why I should be given an opportunity to participate in the tender process, my lord. So this is a fresh matter, maybe can be tomorrow, my lord. Because the respondents are floating the new tenders. They've already floated the new tenders. I should be given an opportunity to participate in this tender, my lord.
15.
Much obliged.
My lords, two more matters, my lords. One, both are service matters, where one is a fresh matter, my lords, against the order of the learned single judge, my lord, dismissing my petition, where I sought from my lords approval of my appointment with A. The other matter, my lords, where notice is already ordered. But any date, my lords,
Court official. Yes.
Your Honor, a writ petition in fresh matter, Your Honor. This writ petition was dismissed for non-compliance of office objection. We have already filed an IA for restoration, Your Honor. Your Honor, we have already complied all the office objection, but the registry has raised further objections because of, significantly it was dismissed on the later date, Your Honor. We have already filed the IA for restoration. Kindly have this matter for tomorrow. There is an urgency.
Restoration
Yes.
tomorrow. Tomorrow?
Tomorrow, Your Honor. So blessed.
My lord, I had filed a complaint with the Karnataka Medical Council. There's an inquiry going on. And now they had passed a few orders, which I had filed a writ petition. But the learned judge has not, one of the points, prayers which I had made was not at all considered. And the two other points which were there, on merits, some things have not been considered. The inquiry is coming up on Saturday again. So I would request you to please, otherwise the inquiry will resume and then, this would be, so I would request you to please consider this
we'll-
for tomorrow.
We'll set aside the inquiry if you are ready, but not tomorrow. It can go to 15.
50. Thank you.
My lords, we had moved a memo earlier this week. This is, the State Bar Council is refusing to enroll the petitioners despite a interim order by this honorable court.
Enroll
was-
what?
They've cleared the 3-year LLB to enroll into the bar, my lords. They had challenged the exorbitant fee before this honorable court, and the court had passed an order, an interim order on 9/5/2024. Despite this order, their State Bar Council are refusing to enroll the petitioners, my lord. And we had moved a memo in this aspect.
You file
Just last-
contempt petition.
Yes, my lords.
When do you want?
Tomorrow, my lords.
Monday.
Please, my lords, the bar exam is scheduled to happen soon, and if they're not enrolled, they won't be able to.
When the exam is scheduled to take place?
I think in the coming month, my lord.
Month, and we are keeping the 8th. Monday.
Please.
Serial number 29, my lord. I seek short accommodation, my lord.
28,
29, my lord, 29.
28 that group. 29,
Pick any date, my lord.
what is it about? All right. 22 appeal, read petition.
Next
PIL.
date, my
No. Old is gold,
lord.
nothing doing. Let it be called out. Then on at that time, you may request for time, not at the outset, yes.
My lord, serial number 17, my lord. I appear for the appellant. Kindly accommodate 2 weeks.
Which one?
17, my lords.
17.
117.
17, let it
My
go.
lord, senior is not keeping well, my lord.
Senior,
My lords.
senior is not well.
Yes, my lords.
You are well.
Yes.
Wait, let it be called out. You be here. We'll grant at that time, we'll grant time, don't worry.
Okay, my lords.
But be here when it is
Yes,
taken
my
up. Yeah.
May I make one submission, my lords? Serial number 71, my lords,
70,
71. This matter was listed on 28th, my lords. There was a mention made by the senior counsel to be taken up at 2:30 on any date. My lords had said, my lords, it will be taken up if possible on the morning session only. That is today, my lords.
not possible.
Today, I'm told, my lord, there's a different bench in the afternoon also.
Sorry. Yes,
Serial number 41, my lord.
41.
In case they have filed the objection, my lord, we have to file rejoinder to the objection.
Interim order is operating.
Interim order is.
Interim order they have obtained during the vacation.
Yes, my lord,
They
yes.
have filed.
Objection is filed. My lord, we want to file the or rejoinder, my lord.
Why do you want time?
Or that rejoinder has to be filed. Rejoinder.
We
2
have
weeks-
filed-
2 weeks time.
Objection 2 weeks back.
22nd. You file IA for vacating. You file IA for vacating or
Objections to the main.
the 22nd July?
Objection, this interim order may be extended, my lord. Till then, interim order.
Interim order shall stand extended first stand over to 22nd July. In order to enable learned advocate for the, in order to enable learned advocate petitioner to file rejoinder affidavit. Interim order already operating shall continue to operate till the next.
That may kindly have it at 2:30.
Which one? This one? Why? Let it be on that day. What is the position? We'll see.
Lord, 69 and 70, I had moved, my lord, 69 and 17 in today's list. I had moved your lordships have, my lord, been pleased to, my lord, directed to be listed today. There's some urgency, my lord, subject to your lordship's convenience, because your lords is not, are not sitting, my lord, I mean, it's a different combination, 2:30. Can it be before 1:30? Anytime, my lord, I'll be here, my lord. Come on.
Lord,
Who is opposing?
Who's opposing?
I am for
Lord,
the
I am
because
appearing,
as appear.
We will have to inform them.
Lord,
Yes,
I beg to appear, my lord, for the respondent in this matter. 5 minutes, my lord, before the, at 10:30, they send us a message saying they're mentioning. We have no idea about the fact it's mentioning because the matter in the NCLT is today. I have come here, my lord, because the matter is there. And they are telling us now, my lord, 5 minutes before the matter that they're going to mention it for an earlier hearing. I'm a very embarrassed situation, my lord.
You are neither audible nor understandable, yes.
I'm sorry, my lord. Can I, lordships hear me, my lord?
Monday we take.
Lord, only thing is, it
Yes,
relates to that byju's.
It is taken by surprise then.
We informed him. It's not that, my lord, it's listed. I'm very
Tomorrow,
lordship's hands, my lord.
tomorrow, 8th.
If it is possible tomorrow, my lord, I'll be grateful because,
Any real urgency?
yes, my lord, because byju's, my lord, that byju's has, my lord, collected, my lord, 10,000 crores. There are
Who?
one, my lord, company called byju's. They have collected 10,000 crores. There's an ED notice, there's a lookout notice, person has run away. There are 10, my lord, NCLT petitions, my lord, for winding up. The NCLT, my lord, had passed certain orders not to, my lord, issue, my lord, go ahead with the shares. Notwithstanding that, in violation that, my lord, they have issued. My lord, NCLT, my lord, granted further orders. That has been, my lord, set aside by the learned single judge. That means, my lord, they'll now start, my lord, issuing shares and then diverting. There's some urgency. That's all, my lord, I would say. If it is possible, my lord, I would be grateful today. Anytime, my lord, subject to their convenience and your lordship's
The
convenience.
same matter, my lord, the same matter is listed before the NCLT as per the directions of the Honorable Court. And Lord, therefore, we have come here to the NCLT to argue this matter.
Tomorrow at 11.
All right. I'm in it.
Tomorrow at 11.
Please.
Very well.
Very
I will come at 11, Lord, but the same application is being heard today by the NCLT. The same application is being heard today by the NCLT.
We do not know anything, therefore we do not express anything.
All right.
Whatever you do, wherever you do, but we will take.
No,
up
Lord, I'm
the-
only saying, then choose whether they're going to argue in NCLT or before my Lord.
That is your choice, whether to go before NCLT or before this court.
Not mine,
Whatever-
Lord. It is their application. It is their application.
Whichever court you prefer.
It is
you
their
go.
application. Either they must argue. No, Lord, I am here before your Lordship.
Tomorrow at 11. Or at
Very
least,
well,
in the-
very well.
at least in the first session. And
Yes.
take up at 11 only, so that.
Please, grateful.
Yes.
Right. May I, my lord? CL number 27, my lord. I am for the appellant, my lord. The respondents have filed the compliance affidavit. I need to file a rejoinder to the same, my lord.
27.
Please,
Compliance affidavit is there when, what is?
my lord, the actual facts have not been brought to the court's notice, my lord.
We'll trace out the actual facts when we take up the matter. Be here.
Please,
Yes. At that time, we'll consider the request.
please.
Yes. He is there. Where is Mr. Holla? We'll take up that matter. So that yesterday's matter, yesterday's unfinished matter, your review application.
Number 6.
ಅವ್ರು ಕೊಟ್ಟರು. ಮುಂಚೆನೆ ಕೊಡಬೇಕಿತ್ತಲ್ಲ.
ಅಷ್ಟೇ.
ಕೊಡಿ. ಇದನ್ನೆಲ್ಲ ಒಂದು ಪೇಪರ್ ಕೊಡ್ತೀನಿ. ಎಲ್ಲ ಹಿಂದೆ ಮೇಲೆ There were some 4 volumes, 4 different paper books. So we consolidated everything and made it to one, just to assess the allotments and prepared a list of dates in accordance with the new one itself.
I am producing this plan. Kamalesh Verma versus Mayawati and others. Yes, plan. Yesterday I was submitting. Yes. One is the notification of the year 1936 was not considered, though it was mentioned in para 11. Yes. And second error apparent on the face of record is plot. Reliance was placed on one judgment, and it has been held that it is squarely applicable to the present case. In respect of the same survey number, it has been rendered. That is wrong, because that judgment was rendered in respect of survey number 1 of Kadugodi plantation, which is in Bangalore. And whereas this property in question is situated in survey number 16 of Pullasandra village of Tumkur district, it is totally two different districts. Therefore, that citation, the judgment which was relayed, was misplaced, and relying on that judgment, allowing the petition is an error apparent on face. These are the two submissions I made. And Lord, one more para 18. In para 18 of the impugned judgment, it is stated that we repeatedly requested the state to produce any document to show that this area was even included in the forest area. There is no material on record to show that it is part of forest area. This is contrary to para 11. In para 11, you last may kindly see. In his endeavor to make home the point, he relies on the notification. We have relied on the very notification itself. That has, yes. Therefore, the observation made in para 18.
My lord, I have produced it in my paper book, my lord, last document.
My lord,
I put everything in one, my lord, compilation.
Your last may kindly say,
IAS,
the
everything.
notification
Page
itself.
209, my lords get that.
Notification itself I have produced along with a memo dated yes.
Two 218, my lord, in the paper.
In the notification itself, it is mentioned. The government of Maharaja Mysore are pleased to declare under the provisions of section 35 of Mysore Forest Regulation 1900 that the land within the limits of which are described in the schedule annexed hereto shall be constituted minor forest under the name of Koratigere Betta Minor Forest Block in the Magadi and Tumkur taluks for the purpose of the rules for management of minor forest issued with the government notification, so and so. Dated 11th April 1929. Even that 11th April 1929 notification is also produced along with the review petition, under which, Lord, Pullasandra in the first entry, district Taluk, Hobli village, survey number is mentioned. In the first entry, Tumkur, Taluk Tumkur, Hobli Golur, village, Pullasandra, your lordship would find in the fourth column. And survey number is Gomal 16. Total extent of the land notified under this notification. For minor. Please.
Paper book, my lord, 218, my lord.
May. Kailash may kindly see, in the notification itself, it is mentioned that management of minor forest issued with the government notification so and so dated 11th April 1929. That notification is produced before this honorable court. In page number 34, typed copy is at Annexure B. Page number 34 to the review petition. Minor forest. Last may kindly see page number 34. Read, government order dated 14th July 1924, sanctioning tentatively or 3 years the scheme for formation of minor forest and directing that the forest regulation to be amended. Annexure B, page number 34. 34 first made. 34 is the notification dated 11th April 1929, which has a reference in the notification of minor forest. May I read the first paragraph? Page number 34. The government order dated 14th July 94, sanctioning tentatively for 3 years the scheme for formation of minor forest and directing that. Oh, 36 is the subsequent notification. The initial notification is, this is the first one. I'm sorry. Lord, may I read? The government of Highness Maharaja of Mysore are pleased to make the following rules under section 35(3) of Mysore Forest Regulation 1900. Yes. These rules apply. Earlier it was district forest not. By resigning that district. Yes. Lord, now may I make a submission? There's no difficulty with it. My submission is. You want to accept it? Yes. Whatever be the definition, it is mentioned that minor forest is the part of the district forest. That has been continued in the new act also, in the present act. This will clarify, section 35. Minor forest. That is exactly for the reason I am drawing your lordship's attention to page number 34. Yes. 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 Now the present section 35 is very clear. Present. Lord, in this earlier, I may read, Lord, that particular. I'll clarify that. May I take your lordships to section 35 of Karnataka Forest Act 1963. But Mysore, I am reading this for this reason. It is, there is a mention about the forest declared under 1900 also. Last may kindly see. Minor forest constituted previous to the commencement of this act. Any forest in the state which has been notified as minor forest under the Karnataka Forest Act 1900 or as protected forest under Indian Forest Act 1927 or the Hyderabad Forest Act so and so, prior to the date on which the act came into force, shall be the protected forest under this act, and the provisions applicable to the protected forest shall be applicable to such forests. Therefore, the contention that there was no minor forest at all holds no water. Because in the very present act itself, there is a mention. And there is a notification specifying this particular area. May I read that section 35(3) in the Mysore Act. There is. Karnataka, it is mentioned Karnataka Forest Act 1900. Then it was not Karnataka, Malad, it was Mysore. Same. 1900 is Mysore. Yeah. Yes. Not this notification is of the year 1936. There were two notifications preceding this 1936 notification, which we have produced at page number 36 and 34. Yes. Forest produce. Since it is a forest, if it is not a forest, the question of regulating forest produce does not arise. Forest produce. That is also a forest produce. Forest produce. Now my submission is no, I would like to make two submissions, last two submissions. Now this is of the year 1936. And there are there was some kind of amendment to 1900 Act. Well, I should may kindly see page number 36. May I read, my lord? For the regulation of use of, first para, for the regulation of use of the forest produce and of the pasturage in the area placed under the special protection hereinafter called minor forest under the provisions of the said section. This was issued in the year 1924. 1924, Lord, there are certain conditions subject to all rights now legally, the third para, vested in individuals or communities. The use of pasturage and forest produce in minor forest shall be regulated by the following rules. Then please come to page number 41. Your Lordship may kindly see page 41. In the very same, subject to condition, this has been, minor forest has been constituted, subject to the rights legally vested in individuals. Part 41, para 18. Quarrying in minor forests shall be regulated by the rules under the Land Revenue Code. Then it was regulated under the Land Revenue Code. Care, however, being taken by the Deputy Commissioner to see that it is not ordinarily permitted in the places where damage is likely to be caused to the forest growth. Thereafter, my lord, in the year 29, that is page number 34. Annexure B. Government order so and so dated 14th July 1904, sanctioning tentatively for 3 years the scheme for formation of finer forest, directing that the forest regulation to be amended by resigning the term district forest. Yes. Yes. Therefore, in the 1900 Act, subsequently it has been amended, and this notification was issued in the year 19. Please.
Lord, please take, my lord, the Mysore Forest Act 1900. What was not brought to your lordship's notice is what is forest produce, what is, my lord, section 35. Please come to, my lord, section 35 of the Mysore Forest Act of 1900. Yes, my lord. My lords, get that, my lord, in the paper book that I have filed, my lord, before my lords, or my lord separately. Yes, my lord. I thought, my lord, because there were 4 paper books, my lord, we made one compilation, my colleague. My lord, please come to section 35. Subject to all rights now legally vested in the individuals and communities, government may for any district, and please look at, my lord, the heading. It is, my lord, make rules for district forests. 1900 itself, my lord, referred to, my lord, rules for district forests, subject to all rights now legally vested in the individuals and communities. Government may for any district or portion of a district make rules to regulate the use of forest produce or of pasturage of any land at the disposal of the government, not included in the state or village forest. Such rules may include, my lord, declare that certain trees shall be classed as reserve trees. Declare, my lord, 2, trees not classified as reserve shall be granted for cultivation raitas. 3, placing of areas in special disposal of the government under special protection. My lord, whole lot of it. Now, my lord, please come to, my lord, section 212 of this very act. What is forest produce? Everything including, my lord, leaves. 212, 25, my lord. Section 2, subsection 5 of the, sorry. My lord, I've, sorry, I should have given, my lord, one more note. Disturbed itself. ಇಲ್ಲ ಹಳೇದು ಇರ್ಲಿ. My lord, please come to 2.5. Forest produce includes whether, sorry. My lord, section 2, subsection 5, my lord. Yes, my lord. Forest produce, bottom my lords get that. Following whether found in or brought from a forest or not. Whether my lord brought from a forest or not. That is to say timber, charcoal, caoutchouc, wood oil, sandalwood oil, resin, natural varnish, black, mahua, flowers. Following whether found in or brought from a forest, be, my lord. That is to say trees and leaves, flowers and fruits, all other parts. Everything, my lord, is my lord, shown as forest produce. Now it is to manage that. If it is, my lord, to manage all these plants not being trees and all parts and produce of such plants, then of course wild animals, my lord, is also part of it. Peat, surface oil, rock, minerals. Mineral also is there, my lord. Mineral can be, my lord, outside.
Next paragraph.
Can I be permitted to, say what I want to say, please, if you don't mind?
No,
Please. Minerals, my lord, can be a forest produce or not a forest produce, my lord, either way. In this, my lord, what has happened? Now, please come back to section 35 again, my lord. 35 says, subject to all rights, now legally vested in the individuals and community. Section 35. Government may, for any district or portion of a district, make rules to regulate the use of forest produce and or pasturage of any land. It is not a forest. It is, my lord, for the purpose of, my lord, regulating the forest produce, which, my lord, includes leaves, trees, branches, everything under the sun. My lord, I have no problem in regulating, but what I am submitting before your lordships is, it is not, my lord, there is nothing like a minor forest. My lord, please look at the definition again in this 1900 Act. 1900 Act, section 2, if your lordships come to. That is what, my lord, this honorable court specifically held. Please come to, my lord, section 2, subsection 11, 12, and 13. My lord, section 211, state forest means land settled notified as such in accordance with provisions of chapter 2. My lord, that is, my lord, a state forest. Village forest means, my lord, land notified as such in accordance with the provisions of chapter 3 of the Act. District forest, District forest includes all lands at the disposal of the government. Therefore, any land, my lord, will be a district forest. But then section 35 only regulates, my lord, it is not, my lord, there is nothing like a minor forest. It only regulates the use of forest produce, which includes, my lord, leaves, all that, and, my lord, the pasturage. This, my lord, was noticed by my lord's predecessors, my lord, in the judgment which my learned friend is seeking to review. And, my lord, their lordships held there is nothing like a minor forest. It is not a forest. It is, my lord, for the use of the produce, my lord, in, my lord, including leaves, trees, everything, branches. What they are now trying to contend is, my lord, it's a forest. No, it is not a forest. It is only, my lord, and even now come back to, my lord, this 1963 Act. Please look at it. The present Act, it, my lord, section 35 of the present Act and 33 of the present Act and definition. The new Act, my lord, which my learned friend read, section 35 of the 1963 Act. 35, my lord, reads thus. Any forest in the state which has been notified as minor forest, sorry. Any forest in the state which has been notified as a minor forest under the Karnataka Forest Act 1900 or protected forest under the Indian Forest Act or Hyderabad Forest Act of firstly 1355, prior to the date of this act coming into force, shall be a protected forest under this act, and the provisions applicable to protected forest shall be applicable to such forest. Now, please come to my lord, the definition of protected forest. My lords get that at section 2, subsection 13. 213. Protected forest means any area, section 2, subsection 13. Protected forest means any area at the disposal of the government which has been placed under the special protection under clause 2 of subsection 2 of section 33 and is declared to be a protected forest under section 35. Now, please come to section 33, my lord. It is similar to section 35 of the Indian Forest Act, Mysore Forest Act of 1900. Protected forest means, my lord, that which is placed under protection, special protection under section 33. Please come to section 33. Please, my lord. Correct, my lord. Any area which would include, my lord, whether it is forest or otherwise. And I'll point out, C and D class lands, my lord, have been given there. Pullasandra, my lord, is a part of C and D class land. And, my lord, I'll point out, they have, my lord, given, my lord, a part of it in Pullasandra itself, my lord, say, survey number 16, for, my lord, safer zone, for, my lord, crushing. I'll point out all that. It's not a forest. Now, please come to, my lord, section 33 for a minute in this act itself. My lords, my lord, it's almost a replication of, my lord, section 35 of the Mysore Act of 1900. Please permit me to read this, section 33. Subject to all rights now legally vested in the individuals and communities, state government may, for any district or portion of a district, make rules to regulate the use of a forest produce or of the pasturage of and land at the disposal of the government, not included in the reserved or village forest. Without prejudice to the generality of the foregoing power, declare certain trees classed as reserved trees, my lord. Same thing which your lordship is found, my lord, in section 35 of the 1900 Act. It is, my lord, for the purpose of regulating the forest produce, which, my lord, is again defined. And, my lord, for the purpose of, now, my lord, look at, my lord, section 2.7. Forest produce, my lord, similar, the similar definition. Sorry. My lord, 2.7, my lord, please. Yes, my lord. Forest produce includes the following, whether found in or brought from a forest or not. That is to say, timber, charcoal, katachu, wood oil, sandal oil, rubber, natural varnish, all that. And then, my lord, please look at B. Following when found in brought from the forest, that is trees, leaves, flowers, fruits, everything. Same as, my lord, section 2, subsection 5 of the Mysore Act of 1900. Ultimately, my lord, question for my lord's consideration is this a forest land? Is this declared as a forest? Answer is no. They have to please permit me to say in my own way, you have a right to reply. Please don't keep on interjecting. I will read it in my own way. Please. It's not fair. Let's have some courtesy and some methodology in doing this. Not a shuttlecock battle, court, where every ball that is sent.
When it is not properly brought to the notice, a particular section, please, I am sorry.
I don't know. In fact, your lordship, just the other day I saw, your lordship very rightly said, when I am dictating, why are you interjecting? This, my lord, it's like that. I don't want to say anything. Ultimately, my lord, there is some methodology in courts. We'll have to follow that, my lord. That's all, my lord. I'm grateful, my lord. Please look at, my lord, B. And my learned friend wants to, my lord, say 6. Let me read it, my lord, 6 also. My lord, no, despite that, your lordships are smiling, my lord. That's the greatness of your lordships. In fact, the other day, when your lordship said dictatable, he went on interjecting. Your lordship smilingly said, don't interject. My thought process goes away. So please, after my judgment is over, please come back and say. And he did that. Therefore, my lord, and your lordships never lost your lordship's temper, my lord. That's the greatness of your lordships. And that's why, my lord, people are so comfortable before your lordship. Youngsters, even they are so comfortable arguing before your lordships. My lord, please look at, my lord. My learned friend, my lord, wanted me to read section 6, my lord. Let me read section 6. Not difficult.
Not section 6, my lord. 33, class 2,
Let me
class
read
6.
My lord, same thing, my lords get that. In my lord, please keep, my lord, 1900 Act and this Act. (33)(6), my lord, regulate, prohibit quarrying stone, gravel, burning lime. Please come to, my lord, section 35(2) of the 1900 Act. Same thing. It's nothing new there. These are all, my lord, all this is relatable to subsection 1 of section 33, which says regulate the forest produce, use of forest produce. And forest produce, my lord, is defined under section 2, subsection 7. Similar to, my lord, section 2, subsection 5 of the 1900 Act. Same thing, my lord. There is no difference between them. That's why I said, please keep both the acts, compare it. It is the same. 35 of the old Act, 35 of the 33 of the new Act. My lord, only one difference is this is 33, there it is 35. Here it is, my lord, forest produce section 2, subsection 7. There it is subsection 5 of section 2. All identical. Nowhere does it declare this to be a forest. Now, my lord, more important is, please come to, my lord, the paper book that was filed, my lord, the appeal memo that has been, review petition that has been filed. If my lords, my lord, take page 34, sorry, 35. C&D class land. My lord, annexure D, page 63, my lord. Let me not, my lord. My learned friend has read 36 and all that. Please come to page 63, annexure D, my lord. (63), my lord. 63, annexure D. Page 71, my lord, is the 71 is the translation, my lord. English translation is at 71. Oh. 71 is English translation. Details of C&D class 71, my lord. Land free from all encumbrance which has been transferred in the first instance by the Revenue Department to the Forest Department for formation of a land bank in the Forest Department. If my lords come to, my lord, running page, Pulla Sandra, my lord, this 16 also, my lord, is included. Page 80. Correct. My lord, 72, my lord, page 72, my lord, if my lords come to, my lord, 72. After detailed examination of the proposal, the government hereby order for transfer of a total of 1,31,866.61 hectares as detailed in the annexure to this order to the Forest Department for the formation of land bank subject to the following conditions. Revenue Department can take back this land from the land bank in the case of necessity of the land to government for any public purpose. Land transfer shall have to be continued as C and D category lands. No notification shall be issued classifying this land as reserve forest under the Forest Act. In the event of releasing the forest area by the Forest Department for mining activities under such circumstances, for the purpose of growing compensatory plantation, C and D category lands from the land bank can be released to the Forest Department as compensation for the same. So, my lord, these are all C and D class lands, not forest land. My lord, is this survey number 16. See first. Now, my lord, please look at, my lord, the notification issued by the government, page, my lord, 70. Sorry, 70, my lord. What is it? Objection statement, my lord. I'm sorry. It is in the objection statement. We have filed, my lord, objections to the review. Objection statement, could there, sir? Yes, my lord. Objection statement to the review petition filed, my lord, on 9th of March, 2022. Yes, ma'am. My lord, please come to, my lord, page 70, annexure R4. Notification prescribing safety zones to stone crushing, powder making units in the taluks in Tumkur. Safer zones, my lords may recollect, my lord, this was initially, my lord, Supreme Court, my lord, directed that there should be safer zones for stone crushing. Thereafter, my lord, there was also a regulation, my lord, made by the government. Now, please come to, my lord, running page 75, my lord. Pullasandra 16 is, my lord, 10 acres, my lord, of government land, not, my lord, forest land. Please look at it. Page 75. Serial number 12, Pullasandra, my lord, second one at page 75. Survey number 16, Pullasandra, 10 acres, government land. Yes, my lord. It is part of that C and D class land which has gone there. My lord, part of it, my lord, they now say that, it will be, they describe it as government land, not as forest land. There's no notification, my lord, issued to declare this as a forest land. Now, my lord, please come back to, my lord, annexure R2 in the same volume, page 31. A joint inspection was, my lord, conducted before, my lord, the lease was granted. My lord, annexure R2. Conducting a joint inspection with regard to the grant of stone mining license in land measuring 3 acres in survey number 16 of Pullasandra. Subject. With regard to the above subject, in your letter referred above, you have requested to fix a date for conducting the joint spot inspection application received for grant of license for stone mining in the land measuring 3 acres in survey number 16 of Pullasandra, which is a Gomala land. My lord, please mark this. It's a Gomala land. According to the joint inspection which has been conducted, in enclosing its report, is enclosed to this letter, it is opined from the joint inspection that since there is objection from the public for grant of stone mining license, file is sent herewith for taking further action to grant stone mining license, subject to the condition that mining operation should not be done through blasting or use of so and so. My lord, there is that word no. No objection is missing. Now please come to my lord joint inspection report itself at page 33. Joint spot inspection has been conducted by the Deputy Director of Department of Mines and Geology, Revenue Inspector, Village Accountant, Survey number 16 of Pullasandra. Land measuring 3 acres in Survey number 16, situated Pullasandra village, Gulur Hobli, Tumkur Taluk, is an area sought for grant of stone mining license by Messrs. Abhimani Publications Limited, that's a respondent before my lords. In the RTC, Survey number 16, measuring 71 acres, 71.21 acres of Pullasandra village is shown as a Gomala land. Previously, nobody has submitted an application of the proposed land. Land in the proposed survey number has been previously granted to others. And after Duras, remaining land is comprised of boulders. This area is not reserved for any public purpose. There is no road, railway station, railway lane, lake, canal in the area. Since the land comprised of boulders, there is no existence of Gomala. Therefore, my lord, they hold that yes, it is permissible to give it. It's a, my lord, there is no forest growth, nothing. It is in the background of this, my lord, a lease was granted. That was, my lord, ultimately, my lord, the forest department said, I'll cancel it. We came before your lordships. Your lordships, my lord, directed. Please look at, my lord, the order passed by your lordships court. At page 23 of the main review petition. Their whole, my lord, contention was page 25 of the order in the review petition, page 25 of the review petition, that, my lord, non-forest activity, my lord, concurrence in central government is required. Concurrence in central government is required, my lord, if it is a forest land. That is why, my lord, this honorable court specifically asked them, show us something to indicate this is a forest area. Paragraph 18, my lord, of the order, which, my lord, of which review is sought for. Repeatedly, my lord, they were asked to produce documents to show that, my lord, this is a forest area. No material, my lord, is produced. And now also, my lord, they have not produced anything. And, my lord, that the other order, my lord, which is referred to in that, that was also, my lord, a land which, my lord, was a minor forest, my lord, in, which is that? Kadugodi plantation. And, my lord, one number, survey number 16, there's one mistake in para 21, that, my lord, they are trying to make, my lord, much of it. Para 18, my lord, this honorable court repeatedly requested, show us something to show that this is a forest area. Nothing was placed. We are, my lord, in a review petition. I have, my lord, given to your lordships, my lord, 4 judgments under what circumstances, my lord, review is permissible. And your lordships have, my lord, said in Kamalesh Singh case, that also, my lord, specifically says, you can't come forward with new pleas, new counsel, and then, seek a review. Therefore, my lord, my submission is that review petition, my lord, lacks merit and therefore it has to be dismissed. In fact, if my lords take, my lord, the judgment compilation I have given to your lordships, my lord, on review, several of them I have kept for my lord's consideration. Not that, my lord, it'll be like carrying coal to Newcastle, my lord. Your lordships are so familiar with all the judgments.
I'll clarify. Let us see. In this matter, barring lease was granted. There is no dispute about it. They have filed an application in the year 2011. It was granted in the year thereafter, my lord. And in the year 2014, Assistant Conservator of Forest writes a letter saying that this is a minor forest, declared minor forest. Therefore, quarry is granted within the minor forest. Upon that letter, competent authority cancels it in the year 2015. What has been shown to the Honorable Court, that joint inspection, etc., without noticing that this is a minor forest, that has been done. Then, so far as, my lord, safer zone declaration by the government in the very Pullasandra village. So last may kindly appreciate. This is not a crusher, this is not an application for crusher unit. This is a quarry lease in Pulla Sandra survey number 16. Total extent of this particular survey number is much more than that, out of which 85 acres has been notified as minor forest. I have produced RTC along with my statement of objections, which clearly indicates
But RTCs of the year 2021, my lord. Earlier RTC were all, my lord, Gomala. They, my lord, after this order, they, my lord, converted into, my lord, some by Sarkari forest, and then, my lord, produce it.
no, me too.
I wanted you to know how it feels.
Yeah. Document number 2, your last may kindly peruse. The RTC produced along with my additional documents application, which clearly shows 71 acres, 71.21 acres is Koretigere Betta block, Meesalu Aranya, that is reserved forest. Koretigere Hill block reserve forest in the revenue records. The document is produced before this honorable court. And the whole survey number 16 is not declared as safer zone as portrayed by the other side. It is only in respect of the rest of the area where the application was filed for seeking license to establish crusher unit, their safer zone was declared, not in the minor forest. These two are two different things. He is seeking quarry lease within the minor forest, whereas safer zone is declared in respect of the quarry unit, which is situated outside the minor forest. And all those joint inspection was preceded to the grant of quarry license, and that has been cancelled in the year 2015. That's all. Yes.
Please. Grateful. Left to us, my lord, we Rajendra, my lord. Mr. Rajendra. MS. Please. Great.
This is number 1. So to be mentioned matter, to Rajendra Kumar Shinde.
Early, my lord, I was not there. Yesterday, my lord, I was not there. I could not come yesterday. Lord, 469, my lord, there are two things. In 469, my lord, the communication issued by the registrar to the finance officer to withhold 25 lakhs out of the retirement benefit. It has been in 461, my lord, the notice. Same person, my lord, one is withholding of 25 lakhs for non-furnishing the bills. The other one is an article charges was issued, notice has been issued. That both the things, my lord, has been negated by the single judge on the ground that the 4 years already lapsed. KCSR would not permit to initiate action against an employee after a lapse of 4 years. On that ground, my lord, it has been dismissed, read petitions, my lord. Against the same person. Yes, madam.
I did not get in that. I'm sorry.
Read appeal number 469.
Yes. No, both were clubbed together. Yes, madam. Yes, madam.
461 is same as 469.
Not same, my lord. There are two different orders have been challenged.
It is already an answer for from appeal. Is the point same? Different order, different matter.
Yes,
Different sets. So is the point same? That is what we are asking. If you are not able to answer, we'll find out here. Simple thing we are asking, whether both issues are same. In both issues are same or not.
In 461, initiation of disciplinary proceedings after lapse of 4 years, that is challenged. In other, not this one, in other, retirement benefits, my lord, 25 lakhs, my lord, has been withheld. That was challenged in the other petition by the very same person.
It's a contempt matter, cell number 2, Mr. Pata BC. Cell number 2, Mr. Pata BC. Cell number 2, Mr. Pata BC. Cell number 2, contempt matter, the Pata BC. Cell number 3, Mr. Prakash MH. Please.
But the complainant is the petitioner in a pending writ petition. When the accused respondents are the respondent number 3 and 4. Lord, may kindly turn to page 28. By the interim order, which was passed on 5/1/2024, not on page 29, because this application was moved for the reason that the respondent herein are proceeding with the construction status quo, and they were injuncted from proceeding further, and they were also restrained from creating third-party rights. But despite that, they have proceeded. On that day, the advocate for the accused was deliberately absent, and they proceeded with the, finishing of the test. Oblige, my lords.
Number 4, Mr. Ashwath Narayan Nayak. Number 4, Ashwath Narayan Nayak. Number 5, the Satish K.
Appearing for complainant, my lords. The order of the single learned judge is partially compliant, my lords. Annexure B, page number 31. So I have been reinstated, but in page 33, para number 7, I shall be entitled to 50% of the monetary benefits from the date of impugned order till the date of his reinstatement with all the consequential benefits. That order is not compliant, my lords. Reinstatement. I've already been reinstated. Yes, my lords. But the monetary benefits is not provided. Para 7, my lords. Page 33. Para number 7, my lords. 50% of monetary benefits from the date of impugned order till the date of reinstatement. With all, no, it's not paid, my lords. Yes, ma'am. On date, my lords. Grateful, my lords.
6, adjourn seal number 7
Appellant in this case.
for amen.
Carrying to the second respondent.
That it was heard on the last occasion. This is regarding extending CGHS Central Government Health Service Scheme facility to retired Information Commissioner, State Information Commissioner minutes. Everyone has been served minutes. There are contempt petition as well as writ appeal is there. In case of writ appeal, there is only after retirement minutes. Rule does not provide for that. Learned single judge has directed. Publish.
Your Lordship, may I place on record certain documents, my lord?
I am for
I'm
the
for the
appellant.
respondent, my lord. I'm for the respondent. The respondent is claiming the CGHS card. He's the retired Information Commissioner. Respondent, my lord, in the writ appeal.
Writ appeal is preferred by the Union of India.
Your Lordship, this is the letter which is given by the.
No.
No, my lord. Your Lordship, just for the information. This is the letter which is given by the respondent to the Information Commission claiming for the reimbursement, my lord. Your Lordship may kindly come to the second page, which is the translated copy. I've provided, my lord. Second para, my lord. In this letter, the respondent had claimed for reimbursement with respect to the medical bills of the mother of the respondent. At second para, my lord, it states, the medical bills submitted by you through your letter dated 12/4/21 for the medical expenses of your mother are being scrutinized as per CGHS rules. This letter is provided after the respondent had retired, my lord. So the current situation is, even though the respondent is getting reimbursement from the state government, it is being given under CGHS rates. So for example, if the respondent pays 1,500 for some bill, the CGHS rate would be 500. So he'll get reimbursement in CGHS rate. I have one more document, my lord, in which he has claimed for certain reimbursement, and I'm producing the statement of the bank wherein the amount under CGHS rate is being provided. That copy I'll pass on, my lord.
Your Lordship, in the second page is the translation. The respondent has claimed 25,491. And thereafter, in the last page, my lord, it is the statement of the bank. At the third column, 17th July. There is a transfer from the state treasury, which is coming up to 12,317, which is almost half of it, my lord. So the respondent is being given reimbursement under CGHS rate. But the appellants are not providing the CGHS card, but they are giving the reimbursement under CGHS rate. That is my submission, my lord. Yes.
My lord, may I make one submission? My lord, the respondent number 1 has been appointed. My lord may see as per this government order dated 14/7/2017, which is as per Annexure C. My lord, the term of office may be seen, my lord. It is for a period of 5 years. And my lord, the preamble says that under the circumstances explained in the preamble above, the terms and condition of service of State Information Commissioners of Karnataka Information Commission shall be as follows. Term is given as 5 years. Then my lord may come to clause 5, medical facilities. My lord, there it says, my lord, there it says that the Karnataka State Information Commissioner and the dependent members of his family shall be entitled to such facilities for medical treatment and for accommodation in hospital as admissible to the Chief Secretary to Government of Karnataka. That's my submission. My lord, that is page 27, clause 5.
Page 54.
I'm sorry, page 54. my-
54, in the writ appeal.
Clause 5. Obliged.
My lordship, one more submission, my lord. I had made a submission on the previous occasion that presently the information commissioners are given CGHS card and it is extended after the retirement. I couldn't get a copy of the CGHS card, but it was issued to the other state information commissioners, which is, I have a copy, my lord. It is just, subject is to authorization to collect the CGHS card. This card is being given to the Information Commission to be provided to the Information Commissioners. Please.
Obliged.
That's only one line submission, my lords. As far as information commissioner who are holding the tenure, during that period, they are entitled. After the retirement, rule does not specifically says, in case of judges' salaries conditions also, same came up before Honorable Supreme Court. I have placed that judgment before your lordships. There are 4 judgments in that. That's it. They are not entitled for obligation.
Seal number 8, Mr. Shailesh.
I appear for the petitioner in the matter. Now, this matter arises out of the Stone Crushers Act. There was no act specifically with respect to the stone crushers, my lord. A This honorable court my lord. In this case, my lord, petitioner is an agriculturist.
It was argued and
argued.
we have filed statement of objection.
Statement also has been filed by my learned friend.
Para 7 and 9 is clear. In pursuance of the direction issued by this honorable court, a joint inspection was conducted to verify whether it is, the crusher unit is causing harm to the neighboring properties.
Please. My lord,
Yes, para 7 and 9.
not, before that, my lord, let my learned friend come. My lord, inspection report. There is three inspection reports. One is dated 31/8/2021. That is the first inspection report as called for by this honorable court.
Yes.
My lord, there were three.
Renewal is deemed extension is under consideration. We have not extended it.
My lord, the unit is,
Even otherwise, Lord, it is not causing any harm
no,
as per the joint inspection.
No,
It
ma'am.
was conducted in his presence only. No. He is a neighborer,
he is mine. He is the neighbor.
not
The-
peer.
Not peer. This fifth respondent has still not appeared. My lord, his land, the fifth respondent has got a stone crushing unit adjacent to my agricultural land. And they increased the capacity in terms of the license which was granted. Based on the order of this honorable court, an inspection report was called for, which the state has filed, that the Pollution Control Board has filed on 31/8/2021, my lord. There, if I be permitted to say, insofar as the stone crushing units was concerned, there was no law prescribed. And by virtue of the order of this honorable court, an act was passed. My lord, this honorable court, while dealing with this matter, because earlier there was no such law, has passed a judgment based on which the act came into force. My lord, I am passing on the judgment. This was the judgment. Hitherto to this, there was no judgment in respect of the Stone Crushers Act. What happened was, after looking at the various aspects in respect of stone crushing units, which had no law, this honorable court passed an order calling upon the state to formulate a policy. If your lordship turns to paragraph 18 of the judgment, may I read, my lord? Lord, paragraph 18, if your lordship turns, keeping in view the facts and circumstances of the case, the position of law, the interests of the society and of those carrying on or intend to carry on the business connected with the crushing of stones, we deem it appropriate to dispose of this writ petition filed in public interest by issuance of the following directions to the respondent authorities. The state shall formulate a policy regulating the carrying on of business relating to crushing of stones by prescribing reasonable conditions, including guidelines and licenses and their periodical renewals. There, they mentioned several aspects, including the pending formulation of the policy and also the safer zones which were mentioned. But please come to G, my lord, column G in the next page. It mentions I may be permitted to read. Such safer zones shall not be located within the limits. Please go to G, 1 kilometer from an inhabited village or any land recorded as forest in government records or any private land which is shown as cultivable in the revenue records. Now, as I mentioned, my lord, my land is situated next to the land which belongs to the fifth respondent. Based on this, the act itself came to be passed based on the policy that was enacted. My lord, my lord, if your lordship sees there, Honorable High Court of Karnataka, this is the policy on regulation and control of stone crushers in the state of Karnataka. Honorable High Court of Karnataka, vide its order dated 10/7/98 in writ petition so and so, directed the state government to formulate a policy regulating the carrying on of business relating to the crushing of stones by prescribing reasonable conditions, including guidelines so and so. My lord, while doing that, it also mentioned several guidelines which had to be followed. But if your lordship turns to the Schedule 1, which is what the policy has been determined. Schedule 1, the parameters for identifying safer zones and regulation of stone crushers as per the Honorable High Court of Karnataka at Bangalore in writ petition number so and so. Such safe zones shall not be located within the limits of 1 kilometer from an inhabited village or any land recorded as forest in government records or any private land which is shown as cultivable in the revenue records. So
what has happened is the judgment was passed because because while dealing with the judgment, this honorable court was also dealing with the right of life of a person to have pure air, water, and air. Now, what has happened, if your lordship sees, when there were 3 inspection reports, 2 inspection reports clearly specify thus the dust emanating from the stone crushing unit falls on the agricultural produce, and that agricultural produce is what we all consume, including the petitioner and so on. That is what has was brought to the notice of this honorable court. Unfortunately, my lord, later on, when the regulations were, when the act was when there were new amendments to the act, this particular policy with respect to private land being declared as a safer land was given a go-by. My respectful submission to your lordship is, notwithstanding the fact that it has not had an effect on that, what I would like to submit is, if your lordship sees, 3 reports have come. 2 reports clearly specify that the tur dal, which is growing in the agricultural land of the petitioner, that's my land, that on that land, the dust emanating from the stone crushing unit is falling on the crops, destroying the crops and making it not usable for human consumption. Therefore, what we have said is, in fact, a request was made that if they could make it into 50 feet, if they can have a plastic molded sheet for 50 feet, or even if they could make a compensation, because the act also provides that I could be paid a compensation because of the loss I am enduring because of that, because there is a victim relief fund. That also is not granted to me. Therefore, based on these submissions, either the unit has to close down or they have to formulate fresh guidelines by which the 50 feet between my land and the 5th respondent's land, there could be a partition by which the dust does not settle on my land, because it is suffering. Not only the petitioner is suffering through his land, but also because he's a cultivator, the smoke and the gas that is inhaled by him, that has caused him tremendous hardship, which is part of the petition. Because of these reasons, I have before this honorable court. My learned friend was referring to the inspection report which he has submitted. The second inspection report, there are 3 inspection reports. The second inspection report which took place was at the behest of this honorable court. Even the second report shows that the tur dal seeds were sown in the area and that dust had accumulated on that particular land. If your lordship turns to the report, a translated copy is at annexure R5. This is as per the order of this honorable court. Please permit me to read the annexure R5, but next page, my lord, last paragraph. Further, when conducted joint inspection of 3.07 acres of land of the complainant, that is the petitioner, Shivaram Pujari, petitioner in survey number so and so, adjacent to the stone crushers unit in survey number 16% over an extent of 1 acre, the half portion in the east is wasteland, and it is found that no cultivation has been done. And in the remaining area, the dust of the crusher unit mixed with mud was found partly here and there. Further, it was found that there was a stone well in the land, and at present it was filled with water, and it was found that adjacent to the stone well area, tur dal seeds were sown in a part of the area. My lord, subsequent to that, without any order from this honorable court, a third inspection was conducted. The third inspection report says at annexure R7, page 31, it reads like this, my lord. The adjacent land of the complainant Shivraj in respect of so-and-so has been inspected. As per the inspection, it is found that Togri dal has been grown in the said land. Upon verification of the crop and the area, it is found that there was no dust spread. The complainant Shivraj so-and-so has informed the officials presently that since it is rainy season, the dust is not found on the crops, and since 10 to 12 years, the said crop is ground in the area, it was not possible to grow irrigation crops. So therefore, I have been suffering because one is the license has been granted without reference to the fact that the government has formulated, this honorable court formulated a policy that any stone crushing unit has to be at least 1 kilometer away from the land and agricultural land. Now here it is very next to my land. Despite that, though there is a change in the act and the guidelines, amendment as you have passed, and that does not find a place. Still, my lord, the fact is because of the suffering of the petitioner, which is also produced because of the fact of his ill health, which is also part of the record, which is not disputed by the other side. In fact, my lord, while looking at this judgment, this honorable court also found this fact. While dealing with the case, this honorable court found the committee consisting of eminent scientists have opined that due to the stone crushing unit, a lot of thick dust is generated polluting the environment. Visible dust containing particles more than 50 units in diameter which settle down in the nose and pharynx. Smaller particles so-and-so remain suspended in the air and are inhaled deeper, which are deposited in the trachobronchial area and lung so-and-so and may induce fibrosis. Now, petitioner is suffering from this. Therefore, my lord, I respectfully pray that this writ petition may be allowed. Either the unit has to close down or I have to take sufficient safeguards to see that neither my crop is affected, neither the petitioner is health is affected, and also the fact that if there is a compensation to be granted, which the petitioner should be open to make a claim for a compensation as provided under the Act itself. That's my.
Number 9. Mr. Unni Krishnanyam.
Lord, this is regarding the revision of pay scale. Lord, we had implemented the 1997 pay scale revision with effect from 28 to 2014. Lord, this is fully covered by a lordship's judgment in writ appeal 955 of 23. Lord, the sole basis of their learned single judge's order is the order of a coordinate bench in WP 2175, which, my lord, your lordships have set aside.
My lord,
That's the only basis for the learned single judge. There is nothing else.
Permitted to read the order of the learned single bench, my lord. My lord, page 45, my lord, writ petition number 18409 of 2008.
48.
My lord, before the single bench, my lord, the appellant has taken the stand that
The lordship's order is in writ appeal 955. Not, I have produced a copy of that order passed on 11th of June 2024 along with a memo.
writ petition.
Impugned in this? Impugned in that. That is 2175 of 22. That is what he has relied upon.
That is relied, my lord, but the contention, my lord, the issue is same, my lord.
the payment of revision of 1997 pay scale, my lord, to the employee, retired employee. The respondent is a general manager who has retired from her services after serving the 3 decades to the appellant's company, my lord. My lord, the appellant has taken 2 contention, mainly on the ground that the appellant management is a loss-making company, and the other contention is the date of implementation is 28/2/2014, my lord, based on the CCA meeting conducted on the same date, my lord. In fact, my lord, in my response, my lord, I have produced the minutes of meetings and also press information bureau pertaining to the CCA meeting held on 28/2/2014, my lord. I would like to request your lordship may kindly see the annexure R1, which I have produced along with my response, my lords. At, my lord, at page number 35 of my response, my lord. Annexure R1 is the Press Information Bureau, Government of India. This may I read, my lords? My lords, this is the Cabinet Committee on Economic Affairs CCA meeting held on 28 February 2014, my lord. Financial assistance to HMT Machine Tools Limited, my lord. My lord, the Cabinet Committee on Economic Affairs CCEA today approved financial assistance and other measures for HMT Machine Tools Limited. The details are as follows. An amount of rupees 75 crore as non-plan loan for working capital purpose. Implementation of 1997 pay revision from the date of approval with one-time relaxation of the Department of Public Enterprises guidelines. Lord, this is very important, my lord. Class B, my lord, this says 1997 pay revision from the date of approval, my lord. From the date of approval is the date of the office as per the office memorandum 25/6/1999, my lord. Except that office memorandum, my lord, there is no other date to implement the 1997 pay revision, my lord. My lord, may I take your lordship to the office memorandum, my lord, for a moment, my lords. My lord, in the CCA meeting held on 28/2/2014, it has nowhere reflected the implementation for 1997 pay revision is from the date of 28/2/2014 or with the prospective effect, my lord. No such words has been used, and nowhere the date has been changed in the CCA meeting held on 28/2/2014, my lords. In fact, the said meeting was conducted only for the purpose of allocation of funds to the appellant's company, my lord, for the purpose of implementing the 1997 pay revision to its employees, my lords. Then, my lord, after clause F, my lord, I may be permitted to read, my lord. The total financial implication of the proposal in the form of non-plan loan would be rupees 136.04 crore. An increase in turnover will bring back business of the company towards a positive growth. Implementation of 1997 pay scale and increase in the retirement age would motivate the workforce. Hence, my lord, there is no restriction has been imposed on the appellant company to implement 1997 pay revision from the date of 1/1/1997, my lord, in accordance with the office memorandum dated 25/6/1999, my lords. My lord, thereafter, my lord, I have also produced annexure R2, my lord, which is a memorandum of settlement arose between the management of the appellant company and also the workman, my lord. In this memorandum of settlement, in fact, the appellant company, my lord, has implemented the 1997 pay revision with effect from 1/1/1997, my lord. My lord, may For a moment, my lord, page 38, my lord, class 3, my lords. May I read, my lord? May I read, my lord? The management offered the settlement to be for 10 years from the date of signing of the settlement. However, the union insisted that the same should be from 1/1/1997, my lords, and may continue till another settlement replaces it, as being followed in another similarly placed PSUs who have implemented 1997 wage revision. My lord, therefore, the management itself has admitted the another similarly placed PSUs have also implemented with effect from 1/1/1997. And for the workers' union, it has been implemented with effect from 1/1/97. But for the officers like respondent, the management has refused to implement from the date of its effect, my lord. And my lord, with regard to this, my lord, I would like to produce a judgment, my lord. May I be permitted to pass on this judgment, my lord? My lord, in this judgment, my lord, State of Haryana Minor Irrigation Tube Level Corporation versus KGs, Uppal, my lord. Para 34, my lords, para 33 and 34, my lords. May I read, my lords? Para 33, my lord, the plea of the appellant that the corporation is running under losses and it cannot meet the financial burden on account of revision of scale of pay has been rejected by the High Court, and in our view, rightly so. Whatever may be the factual position, there appears to be no basis for the action of the appellants in denying the claim of revision of pay scales to the respondents. If the government feels that the corporation is running into losses, measures of economy, avoidance of frequent writing off dues, and reduction of post or repatriating deputationist may provide the possible solutions to the problem. Be that it may, such a contention may not be available to the appellants in the light of the principle enunciated by this court in MMR Khan versus Union of India. Thereafter, my lord, however, so long as the post do exist and are manned, there appear to be no justification for granting the respondents a scale of pay lower than that of the sanction for those employees who are brought on deputation. In fact, the sequence of events discussed above clearly shows that employees of the corporations have been treated on par with those in government at the time of revision of scale of pay on every occasion. My lord, in relevant para 34, my lord, it is an admitted position that the scale of pay were initially revised with effect from 1/4/1979 and thereafter on 1/1/1986. On both these occasions, the pay scale of the employees of corporation were treated and equated on par with those in the government. It is thus established fact that both were similarly situated. Thereafter, nothing appears to have happened which may justify the differential treatment. Thus, the corporation cannot put forth financial loss as a ground only with regard to a limited category of employees. It cannot be said that corporation is financially sound insofar as granting of revised pay scale to the other employees in concern. but finds financial constraints only when it comes to the dealing with the respondent who are similarly placed in the same category. My lord, therefore, my lord, there cannot be a disparity or discrimination when it comes to the respondent or the workman. And for the workers, the management has agreed to implement with effect from 1/1/1997. But for the respondent like officers, the management has refused to implement from 1/1/97, whereas taken the different date for the implementation, my lord, and also taken the contention that the company is a loss-making company, my lord. This contention, my lord. And then, my lord, there is one more settlement, my lord. In my response, I have produced, my lord. There is another settlement.
Correct. Judgment.
Annexure R3, my lords. Para number 45, my lord. There are two settlements have been arose with regard the management with the workers. And whereas in both the settlements, my lord, the 1997 pay scale has been implemented with effect from 1/1/1997, my lord. Page 45, my lord. Page 45, my lord. Clause 3 of page 45, my lord. Duration of settlement. Under the heading of duration of settlement. Page 45, my lords. Of my response, my lord. Statement of objections. Please, my lords. Clause 3, my lord, duration of settlement, wherein may I read, my lords?
Is there any response number? 197. Why we are doing it for them?
This was before the labor commissioner, my lord, duly signed by the officers, by the management of the appellant's company and also the workers' union, my lords, wherein they have clearly admitted upon the insistence of the workers' union, they have agreed to implement from with effect from
But I
1/1/1997.
believe my instructions are that it was actually paid from 28 to 2014. Yes, yes, even for them. Later complete, my lord, then.
Please, my lord, my only humble request is, my lord, I may be,
But she seems to be aggrieved by my decision to implement it from 28 to 2014. That, my lord, at page 190 I have produced. She has not challenged that. That is not under challenge. And secondly, my lord, she's quoting from 2008 judgment. Your lordships have placed reliance on. No, that is not challenged. That decision, my lord, of the Ministry of Heavy Industries and Public Enterprises, which your lordships have referred to in the judgment, has not been challenged.
my lord, only one submission, my lord. In the appeal memorandum, my lord, page 119, my lord, the office memorandum dated 28 June 1999, my lords. My lord, for a moment, my lord, I would request your lordship. Page 122, my lord. In fact, this is with regard to the contention taken by the appellant regarding the implementation, date of implementation, my lord. Nowhere in the office memorandum it is mentioned that it must be prospective effect, my lord. My lord, for a moment, my lord, page 122, my lords. Please, my lord, in the appeal memorandum. That is
No, this
annexure,
is-
yes.
Lord, 1999 OM.
1999, 25th.
Lord, there,
June.
Lord, the relevant one is 2014, my Lord, at page 190, where we were directed to fix and the pay revision with effect from 28 to 2014. There's no point in reading a 1999 document.
My lord, this is the basic for the fixation of pay of 1997 pay revision, my lord. Page 122, my lords. Except this office memorandum, my lord, this attains its finality, my lord. Except this office memorandum, there is no other order. Please, me.
2014, my lord, 2014. 28 to 2014. Yes. Fourteen. Grateful. I'm grateful. I'm grateful. In spelling ARV. Grateful. I'm grateful. I'm grateful.
My lord, appellate number 3, my
My lord, the contention taken with regard to the CCA meeting, my lord.
That is considered in that 955. Your lordships have considered. It's saying
The
that-
CCA meeting, the date of implementation of the,
Considered to a CCA meeting. Not that document is considered in the 955.
Appellant number 3 also is present. Appellant number 3, my lord, Union of India, my lord. That name may be. Also. Along with I appearing for that appellant, my lord. Appellant number 3,
He wants his.
Please, ma'am.
His appearance to be noted. My lord.
PL matters, still number 10. Yeah.
Petitioner Lord. This is a public interest litigation. The respondent number 5 is putting up a construction illegally in the property belonging to the panchayat. That we have made representation to the response 2 and 3. In turn, they directed the respondent number 2 to verify, but so far they did not take any action. The property which is reserved for construction of the general hospital, my lord, to the entire area. The respondent number 5 has created the document in his name, in the name of his daughter, without there being any conveyances, my lord, that he got the transfer, khata transferred, and without plan and sanction that he is putting up construction. That in response to my representation, the response 2 and 3 have said that, my lord, there no such allotment has been made in favor of the beneficiaries. Public interest litigation. Jambaladini village.
Still number 11, green bench matter, the Prakash.
We're not tolerating the interruption in hearing. Go before your study.
With that observation.
Number 11, Mr. Prakash, please.
my lord, for the petitioner, my lord. The petitioner, my lord, is a grantee of acquiring lease for ordinary building stone, my lord. 4/11/2019 is the lease deed executed between the state and the lessee, my lord. It is for 6 acres. On the premise of rectifying a mistake under Rule 55 of the Karnataka Mineral Concession Rules, my lord, the third respondent unilaterally reduces the area by 3 acres, my lord. That is under challenge. A revision was prepared. 55 is apparent if there is a clerical mistake or an apparent error, my lord. It permits them to rectify, my lord.
Yes, joint in. Yes.
Please, please. My lord, no, my lord. It's a matter for disposal, my lord. It's a matter for disposal, my lord. Limited issue is involved in this. Limited issue is involved in this. Under the premise of rectifying a mistake, my lord, they have reduced the area unilaterally. Even the Rule 55 also may read, my lord. It says, my lord, any clerical
or arithmetical mistakes in any order passed by the competent authority, director or the state government or any other authority or officer under these rules, and any error arising therefrom, accidental slip or omission may, within 1 year from the date of order, to be corrected by such authority or officer, as the case may be, provided that no order prudential to any person shall be passed unless he had been given a reasonable opportunity of being heard. No, madam. No opportunity was given, no notice, nothing of the sort. Unilaterally and in an
Order it
arbitrary
is not
manner.
mentioned. In the order, it is not mentioned. Yes.
Please, my lord.
Safety distance, Millard once. Once. One submission. Revision he has filed, and in the revision he has been heard, and the revision authority upheld the order of the competent.
Because revision also, my lord. Revision also, my lord, are irrelevant. Please, my lord. And consequently, both the orders may be set aside and quashed, my lord. Let them hear us, my lord. In the 3 acres, my lord. No, please, my lord, only 6 acres is the total area. Out of that, they say, no, my lord, 3 acres is only, there is embargo. Please, my lord. We will not do it, my lord. We will not do it, my lord. We will not do it. Public.
Yes, sir. The point is revisional authority, it is a continuation of the very same proceedings. Please.
Normally, my lord, just my submission, the original I always say, but we normally uphold the same, my lord. But anyway, because it's a statutory remedy, we are going before them, my lord. Despite an order from this honorable court to conclude the revision within 3 months, my lord, they have taken 2 years, more than 2 years, my lord. We also don't precipitate the matter by coming in contempt petition and all that, my lord. This is a fact I am just placing before this court, not for any other reason. Much obliged, madam, much obliged. Grateful.
December 12th, Shivraj and Narali.
Environment compensation matter, my lords, arising out of in environment compensation.
That's the connected. Yes, that's the connected matters are coming up today. Yes, yes. There are 4 judgments, my lords, where one, my lords, headed by Justice Oak, my lords, followed by, my lords, previous Chief Justice, my lords, where they were held in different ways. So, my lords, that's the issue, my lords. That's why in the previous bench also, my lords, when my lords were sitting with Justice Krishna, yes, at 2:30, my lords, the matter is listed today. At serial number 3, all the matters pertaining to environmental.
My lords, the judgment.
There's a. Yes, my lords, in the separate bench itself. Yes, in that bench, my lords, there were 4 review petitions filed by the petitioner's counsel. Along with it, all the matters were tagged along. And that matter is getting listed today at serial number 3 at 2:30 minutes. Yes, my lords, I will place that on record, and
My lords, even those matters, my lords. What happened, my lords, in 2020, 16th of March, my lords, the first order came to be passed by Honorable Chief Justice and this Honorable Court, my lords, that there is a board did not show there is a statutory authority to levy such. My lord, one more.
Taken over, my lords, in 3 judgments. My lords, I would only
Sir.
request, my lords, let the matters come up at 2:30. My lords, at once, we are giving a solution
I'm-
for them. The problem is that, my lords, they don't want to take a solution.
Solution is already given by this Honorable Court, Annexure C, page 45 in this petition. It's already, that judgment, what happened, my lords, the board, instead of placing that judgment before this Honorable Court in subsequent matters, went ahead arguing that, my lords, there is a alternate remedy.
That's this
My
matter
lords,
may be
that is
called
where there is a, that is
30 minutes.
that is where issues cropped up, my lord, subsequent orders. My lords, this order, page 45 may kindly be,
Council,
please,
and my lords,
please.
4 judgments of the same petitioner councils of his client, my lords, came to be dismissed by saying that you have an alternative remedy. While that was getting dismissed, my lords, I don't want to consume much of my lord's time. My lords, I have it at 2:30, even this matter. No, it's not unreasonable. I'm only. That's I would. No,
Please.
that Judgment, my lords, yes, I made this point of this.
And 38 also, my lords, 12 and 38, both. Please, ma'am.
He's anyways there, my lords.
These-
These review petitions.
My lords, this the 12, serial number 12 and also 38, my lords. It's also the same, similar matter to that of what is listed in 230. There are other writ petitions also.
That's, if today, my lords, the matter, maybe and even tomorrow also, my lords. I have a feeling that, my lords, the matter may be disposed of in his favor, subject to what's the outcome of tomorrow. Today in the afternoon.
My lords, if I'm. My lords, the judgment, your lordships, what your lordships were referring to, are all part of an annexure of this writ petition.
No, I will place all the judgments.
Oh, please.
I will place all the judgments. Bring it to my lord's notice as to what are the judgments and what.
Even we have a compilation,
Show it.
please. 12 and 38 also, same matter. Much obliged.
Grateful. Yes. Number 13.
And for the petitioner, my lord. The notice of the second respondent is challenged only on the basis of the grievance of the petitioner that it is small scale industry and they are not carrying on the business in a large scale. That is the only contention on the part of the petitioner, my lord. It is Annexure A, issued as per the amended rules of Karnataka minor minerals concession rules, my lord. Section rules 15B. Otherwise, an opportunity may be given to file objections and let them hear them. Rule 15B, my lord. And also the petitioner has been registered under Udyog Aadhar. is stated as mineral-based industry in 15B. my lord. And same has to be read along with Schedule 1B. Manjunath G. Kandekar. Along with Schedule 1B.
E4. Definition class E4 defines mineral based.
Item number 28. This is regarding violation of an interim order pending since 6 years. On the last occasion, your lordship asked him to get the instruction. Item number 28, my lord.
'28, my lord, I am filing objection to their IA. Objections are ready.
Can it be called on 8th or 9th, my lord? because there is grave urgency, my business is stopped. 10th.
Serial number 14 also, your lordship. In 14 also, your lordship. Matter wherein despite having a mining lease for over 20 years, all of a sudden they've put it to a stop, your lordship. And he's not been able to operate with over 1 crore of losses, not been able to pay the banks also as a result of their notice to ask us to stop work, despite having a 20-year-old lease, your lordship. Till 2033 we have, your lordship. Your lordship.
Serial number 72, my lord. There's a counseling matter, public interest, which even last time, my lord, I had requested, my lord, serial number 72. If it can be taken up on my IA for hearing, it can be called on the 8th or 9th on my application for IA 1 of 2024.
Please, your lordship. Obliged.
Serial number.
My lords, serial number 56, party in person. Kindly hear my plea today, my lords. After 1.5 years, 56. Yes, tomorrow morning, my lords. Reinstatement, I am in the verge of retirement. 1.5 years over, Judge.
Serial number 71, my lords, the order complaint of non-compliance is of the year 2014. The same has been confirmed by the division bench of this court as well as by the Supreme Court. 2017 complaint, my lords, may be taken up on 10th or 11th, 2:30, my lords. There's some urgency, my lords. 2014, we are before this honorable court. They are not complying, my lords. Any date, my lords, next week, my lords, at 2:30, my lords. Its order has been confirmed up to the Supreme Court, my lords. It has to be heard before framing of charges. It has to be heard before framing of charges, my lords. It's at serial number 71. Any date next week, my lords? At 2:30, I would request, my lords. Yes, my lords. Twelfth at 2:30, my lords. My lords.
Serial number 72, my lords. It's a public interest matter counseling, as I said, my lord, on the previous occasion, likely to commence, my lord, on the 6th or 7th, as on counseling, my lord. No, not contempt, my lord. My lord, if it can be listed on my application IA 1 of 2024 in hearing in interlocutory matters, my lord. There is urgency because the counseling may commence anytime. Counseling for the medical admissions. Therefore, my lord, I am pleading. I had suggested, even on the previous occasion, I had requested, my lords. But hearing on IA, that is, otherwise, my lord, it will be in the hearing list, hearing on the interlocutory application, IA 1 of 2024. But my lords, otherwise, my lord, if the counseling commences, my lord, there'll be difficulty. Again, I'll be again before your lordship at 1:30 or 2:30. Previous occasion also, my lord, I had made the same request. That is why I humbly request, my lord, if it can be taken up on hearing on IA. But if it is listed in the final hearing, this, my lord, it may not reach. That is the difficulty, my lord, sir. That's why if the counseling starts, my lord, on the 7th, it can be taken up on the 8th. But my humble request is, please have it.
We don't recognize any final hearing, admission, hearing, all are for hearing.
True, my lord, but it is not reaching, my lord. This is the 4th occasion I am making this submission. Again, on the 8th, my lord, I'll be, if it does not reach, my lord.
Same thing we are answering, 8th.
My lord.
8th we will be keeping.
Please, my lord. 8th, I'll make a mention, my lord, at least if it can be taken up.
Serial number 53, my lordship. Yes. My lordship, this is regarding admission of an education matter.
Now from 8th onwards, since education matters have some urgency.
Please, my lord.
We have decided to place all 2024 matters in a separate board.
Please,
which will be taken up at the earliest and not be after, not in any case at 2:30. And we'll see whether they're urgent or not. If urgent, we'll take up. If not urgent, we'll go adjourn. But there'll be separate board for education. So you don't mention now.
Examinations are scheduled. Exams are scheduled.
Mention on 8th.
8th, my lord.
8th.
Bill number 21, my lord, to withdraw the petition. The connected.
Serial number?
21.
Learned advocate for the, it is a petition.
Please.
Petitioner seeks permission to withdraw the petition upon instruction of the, upon instructions of the petitioner in view of the decision, in view of the decision of the court in Measure Span Aquatic Products versus Karnataka State Pollution Control Board, which was raised petition number 27433 of 23, decided on 5th June 2024. First one, permission to withdraw the petition is granted, dismissal is withdrawn.
Let's see. Till I file my petition, till I file my application before the concerned authority. That is there already.
Dispose of it, withdrawn. Next. Not dismissed. Then we have to pass this order. We'll pass this order on the same line. You.
Let's serial number 62, my lords.
That pertains to the implementation of ICQ legislation.
Yes. Whenever you.
In that, my lord, the state has, if my lordship may recollect, the time period for implementation had expired. Now the state has extended it up to 15th September 2024.
Now the beneficiaries are completing the process.
There is no urgency.
My petition will become interesting.
No, up to 15th September it will not become.
So my lord, by the time they will complete the process, then I will be running it.
What process?
Implementation of the SRP. We are completely excluded.
But you are, that some interim order was passed.
Yes, my
No, my lord, there is no interim order in that matter. They are completing the process. I will become remedied. My petition itself will become interested, my lord. Third week of.
Just to
Third
put
week
out-
of July. Or 30th July.
My lords, serial number 62, my lords.
30th July. Which date do you want?
22nd to 25th.
25th July. 25th July has not arrived. How can 230 arrive?
My lords, serial number 62, my lords. My lords, matter pertains to doctrine of pleasure pertaining to withdrawal of the nomination to Rajiv Gandhi University syndicate member. The matter is coming up tomorrow, my lords, connected matters. This matter may also be tagged along with that matter, my lords. Serial number 62. Tomorrow.
That matter. Now there, we would like to be enlightened about the aspect that Rule 95 has not come into force.
Yes.
We will make our submission.
That means
So much.
rest of the things that we think it is argued.
The lords have heard is complete. If only that, my lord, I would rather say, my lord, it's bit of confusion, my lord, we clarify.
11?
Yes.
11.
Publish.
My lord, serial number 30, my lord.
11th we'll take up if doesn't reach earlier at 2:30.
So great.
My lord, serial number 30, my lord. Public interest litigation, my lord. It was pertaining to pollution in River Kaveri, my lord. A date may be fixed, my lord. On previous 3 occasions, it was adjourned due to paucity of time, my lord.
Now court master will.
Till number 3. Yuvraj and Arali.
That's, there are total of, I may just pass a list.
Relation to the-
16 cases which are listed today, my lords. And in that 16 cases, my lords, there are a total of 16 cases which are listed today. And in that, my lords, a total of 7 cases. I've just placed it before my lords. The first 2 cases, my lords. Sorry. My lords, serial number 8 to serial number 16, my lords. I've even given the serial number below each case number. My lords, that, my lords, is covered by one judgment, my lords, which was passed by the coordinate bench, where, my lords, it was said that for opportunity must be given before environmental compensation must be imposed. Yes, my lord, serial number 8 to 16, 1-6. In that, my lord, serial number 8 and 9 was listed in the morning. So, my lords, only that 2 may be removed out of the list. I thought it would be tagged now again. No, my lords, it is covered by Justice Prasanna sirs and Lordship Krishna Dikshit's judgment. May I pass the note? Lords, at the outset, my lords, Justice Oak's judgment was specifically held, my lords, that is not applicable to the facts of the case, my lords, especially with regard to environmental compensation. That, my lords, at that point of time, in fact, I have, if I may take my lords to first, my lords, I will shorten the causes so that, my lords, I can come to the other matters. My lords, the judgment which I'll be relying upon saying it's covered, my lords, is at page number 84, my lords, document number 7. He gave a copy. He just gave it, sir. See it. Page number 84, serial number, document number 7, my lords. Yes, my lords, to treat this as a show cause notice. And my lords, that's all
Remember, you are claiming the.
environmental compensation.
Yes.
Yes.
It is not.
Yes.
So it is the same, on the same line as Justice Oak's.
My lords, Justice Oak's order. Yes, my lords, Justice Oak, there are 2 Justice Oak's order, my lords. Number 1, my lords, where the learned counsel for the petitioner, my lords, went on to say that it was held that we didn't have any authority itself to go ahead. My lords, that was specifically,
First direction of Justice Oak.
yes, my lords, that is not applicable to us. Rather,
That both are not, we can't say, but you can argue that both are not.
Same.
it was held by another coordinate judgment also. So, my lords, serial number 10 to 16, my lords, that is at serial number 3.7, 3.8, 3.9, 3.10, 3.11, 3.12, 3.13 would be covered by document number 7, page number 84 of the compilation I've placed before my lords. Sorry, my lords.
Serial number?
Serial number 10 to 16, because 8 and 9 are not before my lords today.
Acha, okay. So
It
10
was
to-
listed in the morning.
Acha, listed in morning. Acha.
Yes, yes.
So
yes.
10 to 16.
10 to 16.
It is covered by this.
Yes, ma'am, it is, it is. That's in fact, Lordship Dikshit Maharaj had mentioned what was the different views taken by the different benches. That's that Maharaj I was able to cull out at page number 4 of my memo, my lords, which I've just placed before my lords now. Now that would give a perspective, my lords, as to where we have done a mistake, my lords, and where the court has come in rescue to both respondent and the petitioner to correct the mistakes.
Page 4 of the memo.
Page 4 of my memo, my lords, I have titled it as notes. Page 4, views of Honorable High Court of Karnataka. Of the memo, I just no, it's okay.
This one.
Yes, my lords. My lords, there are 4 different views taken, my lords. The first view is what, my lords, was passed by Justice Oka at the first instance, where they told that I've mentioned the document at document number 4, but the view taken, my lords, demands imposing interim compensation notice with a liberty to take action in accordance with law if law enables KSPCB to do so. Now, my lords, subsequent to which, WP number 22831, my lords, of 2021, where, my lords, notices were imposing environmental compensation were treated as orders under section 33A of the Water Act, and thereby sending it to appeal, my lords, under section 33B. Then, my lords, it was followed in the 3rd judgment also. Now, my lords, it was in the 4th judgment.
Second category, they are relegated to appeal.
Yes, it was relegated to appeal. Now, my lords, the 3rd judgment also followed the first, that's the 2nd judgment, that is WP number 22831 of 2022. And, my lords, was sent to NGT, my lords, to avail appeal remedy. Now, my lords, it was only in the 4th judgment where, my lords, the mistake was pointed out, my lords, and we agreed to it, my lords, and that is the judgment.
We brought down to these cases are 10 to 16. These are 10 to 16. Serial number 10 to 16, which you have mentioned.
Yes, my lords.
Which would fit into the last category.
Last
number 4.
category, last category. My lords, my lords, I should make a submission, my
Now,
lords.
what about second serial number? What is it?
My lords, both these matters, my lords, one, they have not taken any action.
What is this? Though it is boiling down to number 4. Right?
Yes, yes.
But what was the order in second?
This chief, what they say, you file appeal under 33B.
The demand notices,
Instead of this, we should have.
No,
come
they
like
are
this.
also saying.
There also, where section is specifically mentioned, section is not. That's the difference.
demand notices were construed to be orders under section 33A.
So all are orders of division bench.
Yes, my lords, all orders of division, all chief justice benches. my lords. Yeah.
So we will refer
The 4th one,
all 4 orders.
4th one only, because that stands the law.
We'll say that this last order is more reasonable.
Yes.
So that the.
Yes, yes, we have interpreted that.
Yes, my lords. Now, the last order is where it stands, my lords. That is with regard to final compensation, environmental compensation, which we had levied upon certain occupiers / industries, my lords. Now, my lords, why I had to divide this, my lords, to leave out the first page, what I've mentioned, it's serial number 1 to 7 in the list of cases which I have just placed before my lords. That is only for convenience purpose, my lords. Let's our stance, my lords, is that today, for imposing interim environmental compensation, there was no need to issue a show cause notice. as per the directions of NGT, we have imposed the cost upon them. It was which was interim in nature. That was my lords challenged in writ petition number 1, that is serial number 1 and serial number 2. That is WP number 9941 of 2021, my lords, and WP number 5389 of 2020. We had imposed interim environmental compensation, which was categorized based on the category of industries, my lords. That, my lords, I've explained in my memo also, which I've placed, but I'll take my lords to it in a bit.
Unilaterally.
Yes.
Unilaterally, you want to impose levy interim compensation.
That's I would respectfully say that that's more than apart from being yes, we didn't hear them, yet we imposed environmental compensation, but it was based on an NGT order.
It says exclude principles of.
Yes, my lords, it does.
And NGT order is relied on by you, or NGT order contains a direction?
NGT order contains directions, consequently NGT order.
What kind of direction?
My lords, I may point out.
Let us see.
Yes, my lords. That's document number 1, my lords.
Covered in my favor by the judgment which my learned friend has produced, my lord, at document number 4.
Justice Oak's judgment.
If you want to know what is the order direction by the NGT, then we can let us.
That has also been examined.
No, it's not.
My lord wanted
No,
to
no.
know.
So
My
we are only contesting their argument.
Yes, that
I
was.
understand, my lord. I'm only trying to assist to that extent that this has been examined by the honorable division bench, and their lordships have come to the conclusion that there's no such
So
direction.
prima facie, their submission is anomalous. On one hand, they say in certain category that we'll issue so cause notice. On the other hand, they are saying that we are acting upon the base of the. So we are asking what is the direction?
In a case arising out of interim compensation, the honorable division bench, my lord, heard the matter and came to the conclusion that the
Let him point. What is you relying on what?
That's the NGT order, my lords, based on which.
Yes.
That's the memo which I've placed on record.
That NGT order.
Yes, my lords. It's at page number 31, my lords. Sorry, page number 23, paragraph number 31. I stand corrected. Page number 23, paragraph number 31 at the bottom quadrant, my lords.
We may also mention.
Yes, my lords. May I read it, my lords?
Yes.
We may also mention that hearing industrial unit is not considered necessary for passing the above order, as CPCB, state PCBs must exercise their respective statutory powers by following the procedure prescribed under the statute, even without intervention of this tribunal. The tribunal is only requiring such statutory bodies to perform their duties to uphold the law without going into an individual case. Direction is with reference to data compiled or to be compiled by the said bodies only. This is the observation by the NGT, my lords, where they've said we don't have to hear them.
Where is that?
That's it here. I just repeat, my lords. We may also mention that hearing individual industrial unit at the bottom, my lords, page number 23, paragraph 31. Is not considered necessary for passing the above order. And my lords, this was assailed up till Supreme Court, my lords, and Supreme Court has confirmed this order.
But then in the other category, why you are conceding?
Yes, my lords. The other category we are considering it is because, my lords, NGT has again specifically told us, my lords, that we have to give them an opportunity and then go ahead imposing final environmental compensation.
This NGT observations, if you are right, then will apply to the cases number 8 to 16 also.
Also, 10 to 16 also.
10 to
Yes.
16 also.
That may make the difference between the other cases, that is final environmental compensation and interim environmental compensation. Interim environmental compensation, my lords, is a fixed sum of money which we are going to levy upon a particular industry, which would start with 25 lakhs, 50 lakhs and 1 crore. Now, my lords, final compensation can either be more than that or less than that, depending on the calculations which we have adopted following the CPCB guidelines. So for that reason, my lords, at the outset, yes. please. So my lords, we only going by this, we have gone ahead and we have,
Okay, which are your statutory powers? It flows from which provisions?
my lords, we have got the powers by way of NGT Act. My lords.
Claiming or
My lord is asking.
Yes,
Which specific provision of which of the three acts?
yes.
permit
Water
you
Act, my
to do all
lords,
these things?
Water Act, my lords, Section 33A.
Let us,
Yes,
whether this NGT order was put in challenge before the apex court?
yes, my lords.
And it is attained
And it was confirmed.
on this issue also?
On the order was challenged. In fact, my
Order
lords,
will be challenged on
by a
several.
third party again, saying that we were not heard. And NGT has gone ahead with suo motu hearing.
33A.
Yes, my lords. It's power to give directions, my lords.
Then Justice Oak's bench said that you don't have any statutory power.
That's what had happened at that point of time. Is
Must be-
that,
It is not in air, something.
yes, my lords, what had happened is, I may take that, my lords, that again, my lords, I respectfully would submit. There was, his lordship was not made aware of the findings of the NGT, my lords. And I will show that, my lords, in the judgment itself, where a question was posed by the bench, the counsel was then appearing, and he says, I do not know. And that's recorded in the judgment. And that's how, my lords, the judgment, if I may take my lords to Justice O.
So which is the Supreme Court judgment affirming the NGT?
I'm sorry.
You
my
said
lords.
the Supreme Court,
they
Honorable Supreme Court affirmed this NGT
Yes, my
order.
lords.
My lord wants to know, which is that order?
Yes, my lords. It's here. That's page number 47. Document number 3 of my memo, my lords, which I have placed before my lords for consideration. On my iPad. May I read, my lords, paragraph number 2? The orders which I have just read to my lords from NGT.
No, 1 second. The order of original application number 1038 of 2018.
Yes, my lords.
Was before the NGT.
Yes, my lords.
Which is, where is that order?
That mentioned, my lords, page number 47, bottom quadrant, my lords, serial number 2, paragraph number 2. These appeals are under section 22 of the National Green Tribunal Act 2010, are directed inter alia against the orders dated 10/7/2019, 23/8/2019, and 14/11/2019 passed by the Honorable Green Tribunal, Principal Bench, New Delhi, in original application number 1038 of 2018. And notice this was challenged by the third parties.
Not the persons who were parties to this order.
It was a suo motu action. That was another contention which was taken up, saying that NGT does not have suo motu jurisdiction.
No, two things.
Yes, my lords.
It may, point is, it has jurisdiction is one thing.
Yes.
For exercising jurisdiction, citizen has to be heard in the matter is another.
Yes, my lords.
On which point apex court proceeded in
Yes,
getting this?
my lords, they proceeded. This order was questioned on the point that, my lords, it was, the NGT does not have suo motu powers, and we should have been heard before passing such orders on any of these industries. For which, my lords, the Supreme Court confirms by saying that NGT does have suo motu powers to pass such directions, and goes on to say that, my lords, if I invite my lords to page number 52, 53, my lords. Paragraph number 10.
Then the rest of the things will follow. Right. Already. It's the bill. Whether notice should be, citizen should be heard or not, was it the subject matter of examination by the apex court? Or focus was on the existence of power, not on its exercise?
Yes, it's
It appears the focal point of examination at the hands of the apex court was
yes, it's
the existence of the power, not its exercise, not due process.
I understand.
And Mr. Chaudhary, when you hear them about the justification or otherwise of the interim compensation, they will have right to contend that you don't have the powers. Where is your powers? That is what Justice Oak has said. We have not gone into that, but where we are asking you, where is that power?
That's my powers would emanate, my lords, from
33A is too vague
33A. My lords, it's too vast for, my lords.
Is too vague in context of.
Yes, my lords, 33A, my lords, I would place it this way, my lords, the concept of an environmental compensation, my lords.
This is general power to issue direction.
That's under which methods we can exercise a multitude and manifold things in terms of directing and protecting environment. That's the intent of the entire act itself.
Any formula is available?
Yes, methods,
Statutory?
there is formula. Methods may any one petition methods, we have a formula which
No,
you
in the
apply.
statute it is there.
Methods, we have adopted a formula which has been given by CPCB methods, the Central Pollution Control Board. That's how, if I may take my thoughts, one, I just take the 30 seconds, my lords, in terms of this interim environmental compensation. It was not that, my lords, NGT one day sat down.
There is a formula, it is rightly applied, not applied, accurately applied. That should have it.
Let's make the submission. The interim environmental compensation did not have any formula. It solely went on the direction of NGT to the boards to impose compensation based on the category of industries. I'll take that in the order it's mentioned. Madams. So that category was based on small, medium and large scale, which was categorized as 25 lakhs, 50 lakhs and 1 crore. That's that. For that, there was no hearing which was required. I invite my lords to one page in the Supreme Court judgment.
That is not exist.
May invite my lords one last paragraph in paragraph 12 in the Supreme Court judgment where they have affirmed the findings as well.
Page 50 is Supreme.
53, my lords.
53.
Yes, my lords.
55. No, 50.
53, paragraph number 12.
Oh, there are 12.
And my lords, just before 12, my lords, may I take my lords to paragraph 11 in the previous page, where they say that, my lords, issues, if any, with regard to that should be agitated before the tribunal and not before any other authority. In circumstances, the basic challenge raised in these appeals must fail. And if at all there is any individual fact situation which either needs to be projected or impressed upon, it must be left to such individual entity agency to agitate concerned issues before the tribunal.
Where you are reading?
That's paragraph number 11, page number 52, bottom.
11.
Yes, that's page 52. No, that's the issue with regard to consideration by a third party was laid at rest with the paragraph number 11, where they said, if you have any issues, please go and agitate before the tribunal.
Keeps open the window. On
My-
the contrary, this judgment of the Supreme Court and the directions in paragraph 12
Yes, my lords.
gives the opportunity of hearing.
That's at,
Then presentation must indicate, presentation is right to be heard. Presentation.
that's, I'm stating that, that's the presentation, whatever is mentioned here, that's may read that with paragraph number F, my lords, where it goes on to say it shall be open to the tribunal to pass such orders or interim
In
directions.
any case, these are the directions leaning towards giving opportunity of hearing.
Very well, so I wanted, my endeavor was to point out.
So you just change your submission that all cases are covered by page 84.
No, it is. That's our submission, that's insofar as the interim environmental compensation was that.
No,
we
we'll not simplify in that way in our judgment, but ultimately it boils down to that particular point. We'll deal with everything which you're arguing.
Yes, that there, and yes, that's our submission is, that's the Supreme Court judgment has affirmed three things in our view. That is, that's number one.
Saying affirmed, repeated.
And I will
Would not
show
make
that.
sense because kindly see which my lord has shown. Kindly come to page 53, para 12, last of the sentences.
Yes, that's even then all concerned.
Then all the
Yes.
concerned must have an opportunity to present their viewpoint before the trip. What is that? Present viewpoint is, that's what the Honorable Chief Justice, they have to be.
Yes.
To deduct one single annual increment, the apex court warns principles of natural justice or sacrosanct.
Yes,
For lakhs together interim compensation, you will not hear them. It falls foul of even the basic principles of natural justice.
Yes, I.
So as far as 10 to 16 are concerned, we'll record your statement.
Yes,
That you are conceding that here the notice is required. And in the rest of the matter, we'll deal with
No, and
that.
the rest of the matters, my lords, in so far as serial number.
Rest of the matter will be our judgment, not your concession.
That's
Same.
in terms of the review petitions, I have one submission to be made. Before that, let's just make one summary of the Supreme Court judgment, so that I would place certain things at rest.
Yes.
Number one, the ability or the capacity of the board to impose such environmental compensation has been affirmed by way of the Supreme Court judgment, because we followed the NGT direction. That is not disturbed by the Supreme Court. The second one, if any, that is at page number 10. I mean, paragraph number 10 would affirm my submission with regard to how NGT came up with imposing environmental compensation. That's second submission with regard to where they have to be going in case of any issues, is affirmed in, or rather stated in paragraph number 11, where they say that if they have any issues, they have to go before the tribunal, which is National Green Tribunal, and not before High Court. And third one, of course, have pointed out the personal hearing thing. Our submission is that, we have followed the NGT direction, because the NGT direction has been upheld by the Supreme Court, as of course, His Lordship did mention that the substance has been touched and not the way it has been executed. I do agree with that, insofar as that is concerned. So going by these three aspects, me, in terms of serial number 10 to 16, it's covered by document number 7, which I just pointed out, insofar as the review petitions are concerned, they are on the point that, we don't have any power at all, and that issue was examined at length by the coordinate benches, and I may just place on record one Supreme Court judgment which talks about, in case if there's a change in law or the bench takes a different view, no, not that.
What you are submitting?
What is the proposition?
The proposition is when a review could be entertained,
Review.
Yes, a review petition. Now, serial number 3 to 3.4 are review petitions, And for that purpose, which paragraph? May I invite my lords to page number, my lords, paragraph number 16.8. It's my lords, 2024 to SCC, page number 362.
In 2022,
2024,
24-2.
the latest judgment.
Sanjay,
Sorry, my lords, I had to give that judgment. I give the 2020.
Yes.
My lords, I may take my lords to page number 9 of that particular judgment.
Paragraph.
Paragraph number 16.8. Even the change in law or subsequent decision judgment of a coordinate bench or larger bench by itself cannot be regarded as ground of review. 16.8, my lords.
Yes, even the change of.
Yes.
Will not be per se will not.
I'm just placing it on record, my lords, so that I'm discharging my complete cooperation to the bench.
Whether the judgment now cited is a subsequent judgment or a pre-existing judgment.
That's what they.
Pre-existing.
Pre-existing. That is the 16th March 2020 judgment. my
Then
lords.
makes no difference.
No. That's what is being quoted by them.
It can be ignored. That's what the apex court has said. If pre-existing judgment of a binding nature is ignored, that is a ground for review.
Please.
Apex court was considering
That's the judgment.
47 rule 3 perhaps of CPC. This is a prior judgment which they are now pressing into service.
They are pressing into service, my lord. Justice Oak's judgment of 2020, which, my lords, has been told is not applicable by a subsequent bench.
No.
Yes.
No, you can't say that it is so.
My lords,
No, my lords, may point out
if
that.
he points out, then
It has taken a different view, but not in express terms as stated.
My lords,
That
may
is
make
not-
the submission. Page number 72 of my memo, where this judgment has been referred.
Any subsequent bench said that this is not good law.
I'm sorry, my lords.
Any subsequent bench pursuant to Justice Oak's judgment
Yes, my lords.
has stated or expressed that this is not a good law.
They've not used the word good law, my lords. It may not be possible.
So have they departed expressly?
No,
Let
no,
us
they
see.
have not told that expressly. That is not being told. But what I'm pointing out to my lords is that
We wanted an answer that you said he could and commit a mistake.
He'll not say.
Yes. Yes, please.
my lords, document number 5, my lords, that's a judgment which I'm pressing into, my lords, where that's Suhas. Sorry, my lords, that judgment is not here. By the time they finish arguing, my lords, I'll place that before my lords, where 2020 judgment was recorded, my lords, and it went on to conclude that, my lords, the powers are there for the board to impose environmental compensation. I'll just place that on record by the time they finish it. These are my
Because their
submissions.
apex court said you have power to take suo moto proceedings. See how you are going to construe the judgments. You are going to construe the judgments depending upon the point that was articulated for consideration. That is articulated at para 16 of the said judgment.
That's a referring to the Supreme Court.
Were interim orders, not what happened, there were 3 interim orders granted to the NGT. Various persons challenged it before the Supreme Court to say NGT has no power of suo moto action.
They said that you have power.
That was the power which the Honorable Supreme Court affirmed.
Yes.
Later on, the NGT passed a final order in the matter. And in that, they say that it should be heard.
Yes, that we have made a submission. That's that interim order attained finality, my lords, after the final order came to be passed in 2022. And that, my lords, the output is the last judgment, my lords.
Not that. That argument may not hold water for this reason. Whether interim order, final order. When apex court interprets the provisions of law,
Yes,
it becomes law under 141.
No doubt on that.
Is
That
the
is-
the efficacy of pronouncement of law by the declaration of law by the apex court under 141 is not affected by the nature of the proceedings that are brought in challenge.
No, I'm not saying that. What I'm only trying to point out is there were 3 interim orders that was challenged before apex court. The principal question there was no suo motu power. So
The
they
court said yes.
confined to that question
Yeah.
and said, we hold they have suo motu power.
Thereafter, final order came to be passed by the
Then
NGT.
Final order came to be passed. It's a very detailed order which gives directions to say you must hear the polluter, you must assess the damage, then you must recover it. My learned friend is not pointing out that.
That's because, I've already said that. That's so far as the final compensation is concerned, the issue is covered by document number 7, which I've placed on record. Yes, we have to hear them. We will hear them. These are I just placed that one judgment. That's where 2020 judgment was discussed, and even mentioned that probably it was not brought to the knowledge of the bench. That's the thing. I will make sure that it's before my lords. I don't know if somebody will start.
So 10 to 16 we dispose of today.
Yes, yes.
We record your concession.
Yes.
That you are fairly conceding that this will apply. And the show cause notice is.
Let's concede,
fairly
we can say this
Not-
judgment is applicable.
No, you kindly tell us frankly, you want to record the concession or we say that it is.
It is covered by,
As appearing for body, you may not be able to concede. We know, understand.
yes, it may be recorded as their submission.
So both submission will record and then,
Yes,
yes.
this one. That's, if I may request the court officer to have this judgment, WP number 6624 of 2020. 6624 of 2020. We have another copy.
Yeah, please.
27. So 10 to 16 we are disposing of. Rest of the matter for your further assistance on 22nd. So 10 to 16, 8 and 9 may be notified on
Plus it's listed on 9th.
9. It is already there on 9.
It's already there, 9th. That's
So
that.
10 to 16 get the appearances. It will be disposed of. Give all appearance. So we'll dispose it in the lines of 84 without referring to any other order.
Yes.
Wherever we need to decide, we'll refer all the orders.
Yes, my lords.
Right?
I don't know why they're doing such.
Bifurcating so that there is no load on us, load to dictate.
That's the reason we are even pressing on the, though, my lords, I don't know if I can say this.
Anyway, because elaborate reasoning is necessary.
There's,
because of what
yes, I do agree on certain things, my lords, in my capacity, my lords, as an advocate. But my lords, I'm sure even Nagaland sir would agree. Certain things even which, in fact, that's the reason, my lords, I'm even saying that the other orders, you don't have to like contest on it and reducing the list, the size of the causes.
Some orders are indefensible. So the council has a very difficult task to try and defend it. After all, my lord, what we are saying is you want to pass an order, interim or final. Give us a notice, tell us what is the basis on which you have done it. My lord, instead, what they did, they looked at the interim order in the NGT and without any application of mind, they just simply said, pay 1 crore.
That's on instructions. Can I make one request, my lords? If my lords, they're not pressing into service any other ground apart from saying principles of natural justice, qua hearing them has been violated, my lords. It's my request, my lords, all these notices may be dealt as show cause notice, my lords, and sent back in all cases.
Keeping open all contention.
Yes.
Yes.
Yes, my lord. Both interim and final orders, my lord, in
Yes.
many cases.
Yes.
Interim and
Because, my
final
lords,
orders.
I don't want to be
Then all
disturbing.
other arguments are not
Not
necessary.
necessary, my lord. That's what I was trying to say, my lord,
If they-
because
if
on this
they do not
tenuous,
press on.
on this.
My lords, my petitions, RPs are on a different footage. And the
That has to be
points-
considered.
RPs and also serial number 10, my lords, which is the petition in which I am, this council is.
So all impugned orders to be construed as a show cause notices.
Keeping
and
open
the
all
matter to
contingencies.
be remanded.
All the petitioners are not raising any other aspect except principles of nature.
Before your lordships.
For your lordship.
In this court, we are not
Ah,
raising.
Next,
I've raised. In 10th petition, my lords, we have raised.
all contentions of all sides are open before the authority.
Please.
That's
Well, that's another day.
Why did you add this?
Then it will be, we are simplifying the our order also. Not going into the niceties of the thing. Now, this will be upon concession.
Yes,
This will be upon concession.
My lords,
It has to.
we will hear them. We'll hear them.
We'll say broad consensus emerged in course of the hearing that
but then if you want to
Please.
challenge that.
Lord, only one
That's
submission I have, my lord. There are two matters in which I appear, my lord. 3.6 and 3.5 serial number in today's list. In serial number 3.6, there was a further order made after the initial 1 crore.
No, if this order goes, a consequential order also will wither away.
Yeah, I have already amended there. 3.6 amendment is already allowed.
Done.
In 3.5, my lord, that order came to us later, my lord. I filed a memo to that effect, my lord. So that we also have to.
See. All further orders also will go.
Please. Please.
Only they have to go away.
subsequent. order.
Subsequent.
Please.
No
So
problem.
all subsequent orders pursuant to this will go because this goes.
My lords,
Advantage of a live proceedings, my lords, is that just got instructions after seeing it.
It will not go.
my lords.
So it will be treated as show cause notice. my lords.
That's what.
Look, correct,
Go
one
on, yeah.
question. If so, feeling agree with parents.
You don't want another brief. Anything. We'll get another
pass
brief.
that list.
Yet.
So 3 point.
3.1 and
3.5.
5.
In 3.5, my lord, amendment is already made.
3.6 ಆಗಿದೆ.
In 3.6 amendment is made. In serial number 3.5, there is a further order.
Anyway, my lord has said, Lord has answered your point. Since this base order, which is the substratum, if that base order is construed as a show cause notice, rest of the things will pale into insignificance, whether you challenge it or not.
Yes. Please.
So all are gone.
All.
So the order will get after 5 to 6 days. We are making it very clear.
My lords, one council, one submission. If feeling aggrieved, my lords, the parties there afterwards, they should have the opportunity to challenge even on the other legal grounds available.
It goes without say. It goes without say.
The High Court such arguments are made.
Ah.
Arguments.
Because my lords, we raised.
Fresh cause of action.
It's a fresh cost.
Oh, we raised.
Grateful minutes.
No, my lord, I'll understand right to vociferously defend it. Compliment him, my lord, on the right conclusion that the authority must act fairly. For that reason, they must go back. I think that's,
Correct.
as a law officer, my lord, I think that was an important stand.
So we appreciate that.
Serial number 1.
TN Vishwanath.
The petition. Let's go, Shita. Which notice?
Well, all service of notice.
Service. One Mr. MS Kaushik has entered appearance.
Kaushik has entered appear. And you appear for him?
I appear.
Awaiting service. That is review petition.
Kaushik.
Kaushik, MS Kaushik.
MS Kaushik.
Kaushik.
So you are appearing.
They have filed wakalat, I am representing.
Short service, not office of the condition. Since R1 and R3, 2 R3 are represented by learned
R1 to
advocates.
3.
So there is learned advocates, Mr. Kaushik.
MS Kaushik.
MS Kaushik.
Kaushik, comma. The office of the services requirement of serving the notice is done away with. And the office of in this regard is dispensed with.
One of the point which may arise in this is a review petition is filed by a person who is not a party in the writ petition or in the writ appeal. Review is filed by a person who is not a party in the writ petition, also not a party in the writ appeal. If he is aggrieved, they will have to challenge at least the writ petition order, if he is affected in any way. My lord, the point is that.
Because of 63 Supreme Court.
Yeah.
Yodev Singh.
Yes. What happens is the government appeal has been dismissed. In this case, the government appeal has been dismissed. They had filed contempt, both of them were combined together. Government appeal was dismissed, saying that we don't file any reason. The government had no knowledge of the facts. There are numerous litigations pending between us, all of which have been suppressed.
No, you can seek review of that order by filing a separate petition.
Which?
Because of 5-judge bench decision of the apex court.
See, the writ appeal order only, in the writ appeal,
It happened.
what happened was.
But you are not party in the writ petition.
I'm not party in the writ petition, I'm not party in the writ appeal. They filed contempt. What happened was, originally, there was a writ petition in which an order was passed. They filed contempt saying that change kata. Contempt court dismissed it saying that there is no specific direction. Then they filed an application in the original writ petition and the learned single judge directed kata to be transferred. Kata was not transferred, they came up in contempt. Meanwhile, it appears that the government filed an appeal.
Why can't you see one paragraph in that judgment?
In the writ.
Can't you see?
Yes.
One paragraph in that judgment.
Yes, ma'am.
Please see. Do you have that judgment? Shivdev Singh versus.
I don't
so
have
and so,
Shivdev Singh.
63 or 64 Supreme, 63 SCR.
I don't have that judgment with me. 63. If you are not a party, separate petition can be filed, which is the by way of a review.
Not review, it's by way of writ petition.
Separate
itself.
writ petition.
That is followed by another coordinate bench of this court, Justice Swami.
Yes.
The bench headed by Justice Swami interpreted that 63 as SCR, saying that in such circumstance, you have to go before the learned single judge. Notwithstanding, that order is affirmed by the division bench. It's some other matter.
But again.
ILR 91 or 92 Karnataka.
But
It's there.
if I may say one more thing, there appears to be one 2023 judgment in a review petition where I said, even if I am not a party in the civil appeal, I can file a review petition. That is, in SLP, it's not reported, but it's a review petition, civil review petition by the apex court.
ಸಾವಿರ ಜೊತೆ ಬಂದಾಗ ಒಂದು ಜಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದೆ. You should follow.
Sixty-three, 1909.
Page number?
63,
Shivdev Singh, page number?
1909. AR 63, Supreme Court 1909.
1909. Right.
Tara. 1963. 63 Supreme Court. 1909. Review applicant was not a part. What is your claim?
My lord,
You are claiming the same property.
this property belongs to me. He has been trying to get this property from me. Series of suits before the assistant commissioner, deputy commissioner, none of which he has, in fact, I've got a whole list of matters which he has completely suppressed before this honorable court, both before the learned single judge and before your lordships. Then what he does, the moment an order is passed in the contempt where they said change the kata, he immediately gets the kata changed and sells the property to 5 people. He knows that we have filed the review in February. He sells the property. It's just getting more and more complicated. Therefore, we filed review here. Because if your lordship sees in the Shivdev Singh, my lord, paragraph 8, my lord, there is no reference to any appeal being filed. It says writ petition was filed since the person was affected by it and he was not made a party. The lordship said, yes, under 226, there is no difficulty in the same court reviewing its order because he was not made a party. In this case, it has gone one step further. It has come before your lordships. Therefore, we are seeking review before your lordships.
No, it's writ petition is, writ appeal is dismissed. If the writ appeal were to be reversed, we would have understood the logic. Two situations.
No, I understand.
Ah,
I understand.
then it does not come.
But
Because
that-
you are not a party,
I was not a party, but now,
a party.
now, my lord, the problem like this is, the government's appeal is dismissed. Please, in this case, I was slightly, one more complication, the government's appeal is dismissed. If the government's appeal is dismissed, my review is not going to stand. Because an appeal against that order has already been dismissed. Your Lordship sees, I was faced with a problem like this, that an appeal was filed by the government could not place any material on record. In fact, your Lordship pointed out, you are not able to show me anything. They didn't have any knowledge. If I had been made a party, I would have brought everything to the notice of your Lordship.
You never knew about all this process.
Nothing, my lord.
Until this.
I came to know when they went to change kata.
Matter in issue is there is a grant in our favor. Now we filed a representation that on RTC our name is left out. The dishonorable court directed the Tahsildar to find out the genuineness of the grant. Tahsildar after verification found that our grant records to be genuine. Then Assistant Commissioner by a suo motu order said, no, that should be cancelled. Now the learned single judge said, yes, he cannot suo motu, by virtue of suo motu, he cannot do it, that is the order. Then subsequently, there is another proceedings initiated, he claims that there is a grant in his favor. There also Tahsildar gave a finding that it is not genuine. But Deputy Commissioner gave a finding, no, their land is also there, that is now stayed by in another writ petition. So that is an entirely different proceeding, that order in his favor is also stayed by the deputy, by the dishonorable court.
The Deputy Commissioner holds the grant in his favor is fraud.
Stand today.
Grant in my favor is correct. That was completely suppressed.
Stayed.
That was completely suppressed.
No, suppressed is not.
And
the
FIR
issue,
is
that
filed
subsequent order.
against him.
That is a
Completely
subsequent order.
suppressed.
Suppression or no suppression. But fact remains that he was not a party.
He was not a party.
And as he
No,
directly.
he is not a party. If he is not a party, well, then there is a writ petition where the order in his favor has been stayed. Now there is no order in his favor.
No.
Now he claims.
No, can't say there is no order in his favor. You can only say that order is stayed.
Stayed.
When
But the
order is
position
stayed,
is-
order continues,
in-
but in suspended
The
delegation.
legality in this case is only concerned about the Assistant Commissioner exercising suo motu power.
My lord,
Suo
there
motu
also
power
one
is
more
not
submission.
flexible.
To be fair to the court, they should not have cited this judgment. This judgment had been referred to a full bench where it held that the Deputy Commissioner under 136(3) has got power. Well, this also was not done. Well, what happened was they used the system to get orders.
Not correct.
My duty to tell your lordship what is the judgment, what is the latest judgment. Well, this is long before this 3 judges have held otherwise.
That 136(2) does not arise at all in this case.
You're part of your arguments.
It is
That's
not,
all.
we
I am
have
not
not
saying
cited
anything.
that. Judge. We have not cited that.
Not 136 order.
Not 136 order, my lord, it's a suo motu order passed by the Assistant Commissioner
That was,
against the order of the Tahsildar. So 136(2) is not.
and Deputy Commissioner reversed the order of the.
No,
State
Deputy
Commissioner.
Commissioner did not reverse. There is a separate proceeding altogether in respect of his case. In so far as my case is
Your lordship
concerned,
judgment says the Deputy Commissioner has passed under 136(3) is non-est.
that
This
does not,
submission is supported by a coordinate bench and so and so, so and so.
that does
that
not arise
judgment-
in this case.
Has been
That does not arise here.
overruled in this is part of
If your
paragraph
lordship
3 of
look
the
at the
judgment. But I'm not.
Single judge's judgment, my lord, in the present case, it is only an order of the Assistant Commissioner. If need be, my lord, I'll produce all the documents and file my objections.
Otherwise we will be affected. The limits in the settings, order is already affirmed with the division bench, therefore my order does not exist. It would be contested. He may say. Changalavarayan. We are just proposing like this.
My lord.
We will, your apprehension is that this, since the order of the learned single judge was affirmed in appeal, the learned single judge may say that my order has merged into the order of the the division bench. If that is taken care of, we will be.
My lord, if I am permitted to file an appeal, I'll be happy.
Huh?
If I am allowed to challenge the order of the learned single judge
A writ petition.
without,
Writ
in the
petition.
writ petition, without reference to the dismissal of the government appeal.
That's what, only that much you will be. you have to
That's
be
all,
protected.
because I have a place to ventilate my
We understand that.
grievance.
What do you say? Suppose if order of the learned single judge has merged into order of the division bench, how learned single judge should treat the matter?
No, my lord,
Because that aspect is not
decision by the-
considered, as you rightly
the
pointed out.
decision by the learned single judge is confirmed here. But if your lordship make an observation, it does not affect persons who are
No,
not
whether we are
parties.
right in making that observation. There is no order which he can execute. So review, we can examine. Since it's a case of fraud you are putting forth.
Yes, but there's no order I can challenge. My lord.
Changalavarayan,
My lord, there's no order I can challenge.
you have to challenge that. Changalavarayan.
Pardon, my lord? Changalavara Nayudu.
Changalavarayan.
Yes.
No, that is a case of fraud. There is no pleading of fraud here.
I'm not a party anyway.
There is no pleading of fraud.
Now in appeal, in review.
In review petition also, there is no pleading of fraud here. No, he takes a
My lord,
subsequent.
Where
internal
somebody
proceeding.
suppresses facts.
So have you taken up that contention?
Yes.
There is no allegation of fraud.
Either.
Because we have adopted order 6 rule 4 of CPC.
He only says
It is,
not disclosed.
it is, here I have said, the first respondent has deliberately concealed pendency of proceedings before this honorable court and not implemented intentionally to gain unfair advantage and defeat the claim of genuine grant. Very
DC order
conduct
is
of the
after
first
what-
respondent
what is the date of the
establishes
DC order?
he has intentionally not disclosed the pendency of proceedings. In view of suppression of material facts, the order passed will take away the petitioner's right observations made. Well, if he suppresses facts and it
Yes,
leads
they have
to an
taken
order
up-
in his favor, that amounts to fraud.
He was a party. He was
But-
not made a party. He is an interested person.
No,
There
no,
is an
he is
order
not
in his favor
interested
that has been
because,
stayed before the learned single
because,
judge.
my lord, Tahsildar and Assistant Commissioner holds there is no such grant in his favor at all.
Anyway, now there is an order which is put in challenge and it is stayed.
It is stayed. In
Not
his
make him a
favor, it is
party.
stayed. But,
You did not make him a party.
no, in this proceeding, when this learned single judge decided that matter, that occasion did not arise. Because the single judge was only considering the validity of the Assistant Commissioner's order. Where is sumo moto, our name was there in the record of rights. If he has an independent claim, that's a different issue. Record of rights showed our name. Tahsildar directed our name should be entered. Accordingly, name was entered. Assistant Commissioner Sumoto by an order said that it should be shown as Sarkari, not his name. Assistant Commissioner
Anyway-
did not pass an order in his name.
Anyway, there is a finding by
No.
statutory authority to the effect that your grant is
There are
fraudulent.
two contrary,
Yes, genuine.
contrary orders. One Assistant Commissioner says it is Sarkari. Deputy Commissioner in 136(2) proceeding says, no, it should be entered in his name.
Where's the list of cases?
His is genuine and his is not genuine.
Yes, Mr. Lee.
Let me do it. Yes, let me.
ಇದೆಲ್ಲ ಒಂದು party, no?
ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಕೇಸಸ್.
All these. But there's so many writ petitions, all of which are now getting listed before, I think, Court Order 21 on the 9th. Well, there are so many petitions, my lord. I got a whole list of them. I got a whole bunch of papers.
Only one
Nothing was
petition.
mentioned.
Only one pending.
And I'm interested because I am the person who's been granted it. I'm in possession. I'm an ex-serviceman. I'm in possession of the property.
RTC stands in our name as on date.
But you have suffered an order which recorded your grant is not genuine. Whereas there is an order
No,
in his favor
We
which
did
says
not
grant
suffer.
in his favor.
No, no,
is
I'm
genuine.
sorry, it's
Yes.
otherwise. Tahsildar passed an order saying that our grant is genuine.
No.
No,
Reversed.
yes, second, my lord, against that, the assistant commissioner, you lordship may have a look at the order passed by the learned single judge, my lord, which is under question.
My lord, Deputy Commissioner in 22 has said that the grant in his favor is a
That is
fraud.
not part of this proceeding at all.
But because you have suppressed it.
No, that is not part of this.
Property is
proceeding.
one and the same.
The
Property is one and the same.
Order, what is
6/7/22 Deputy Commissioner holds.
Yes, yes.
Hmm? This. There are first order date. Lord, may one submission, my lord, one factual mistake. The order passed by the learned single judge in 2020.
My lord. I didn't catch your lordship's last portion.
Status quo.
Yes, status.
Status quo with regard to entries.
Status quo, the properties.
Did he allow the review?
My lord.
Huh?
In
We were
particular,
permitted
and
to-
also entries, my lord, revenue entries will get changed.
Lord,
Yes, grateful.
Lord, we were permitted to file our objection.
My lord, I don't know what are the
No,
technical
status quo,
objections.
whatever
against my
entry is
lord.
there, my lord, it will remain.
Revenue entries, but that's all. We may be permitted to file whatever documents, extra documents you got to show all the suppression. I'll give it to them early.
Thing
So,
is suppressed, I wanted to show 2020 single judges order,
yes,
2020
Grateful.
single judges order, the order in his favor is subsequent. As on the day we filed the writ petition disposed of, there is no order in his favor. That's the present entry is included. In our like, our client. That's an issue. Hmm?
nine zero nine.
Miss Chandru.
Grateful.
This is number 2. Mr. Sundareshan, 14%. Number 2.
I appear for the respondent in this case, my lord.
Namaste, Honorable.
I appear for the respondent. Yesterday I filed wakalat, my lord. I am permitted to file a formal statement because the contempt was disposed of after taking the calculations into consideration and the date order was passed. Now I find, of course, I should not find, point out the technical mistake.
I say, they have suppressed a document on which that particular decision came. It is not the thing that they should not have done that suppression. That suppressed document is superbly, monumentally more powerful than all that they have submitted and all I have submitted. Such is the reason. So, such being the case, they cannot contest that particular.
He wants to file objections.
22nd July. Please.
Begging Honorable Court's pardon, my lord, begging Honorable Court's pardon, I beg to state. Pardon?
We will have to permit them to.
Let them file. Now they are here, when I say about 15 minutes, they will get more information to file a better one, my lord. That's the
Not
reason why
necessary,
I'm.
not necessary, my lord. Not necessary. my lord.
You serve a copy also.
Yes,
on
sure.
your objection.
I'll do it.
This time at least let it come with writ presentation form also, please.
23rd July.
23rd, please.
And no further adjournments, my lord.
I don't
please.
want. I'll not take for.
Number 4.
Appealing for the petitioner. The petitioner is a MBBS student, my lord. She completed her first year MBBS classes and she did not complete her.
What happened to other students?
My lord, I have filed an affidavit, my lord. I have filed an affidavit on 2nd July 2024. And with respect of other students have been allowed, my lord. And one particular person, that is Varun Venkatesh, was my student, my lord. That is writ petition number 1103 of 2021. That particular order, my lords, would find at Annexure A, page number 5. The relevant person, the student's name, my lords, would find at page number 9. That is WP number 1103 of 2021. And that particular student also, my lord, similarly placed like me. He was my classmate, my lord, in the same institute. Others are from different institute, my lord. And he completed, he did not complete the first year. And then he was permitted because of the COVID-19, my lord. The learned judge order, common order, my lords, would find at page number 10, my lord.
Where is your
The
affidavit?
affidavit, my lord, 2nd July 2024, I have filed it, my lord. Second July 2024, my lord. Day before yesterday, I have filed it, my lord. Sorry, my lord. I'm told that, my lord, there are many other students. This is one particular order which has been passed, my lord. The one particular student I just want to highlight, my lord, because I have information about that particular student because he was my classmate. The order starts at page number 5, my lord, Annexure A, page number 5. Hope my lords has that particular affidavit, which I had filed on day before yesterday.
Your batchmate?
Yes, my lord, he was my batchmate, my lord. Para number 3 would be relevant, my lord.
There are two.
Para number 3, my lord. Para number 2, the batch of the petition have been mentioned. Para number 3, my lord. The university conducted re-examination in November 2024. Now presently I am studying third year, my lord. I have given my exams of the second year. My result is not declared on the count that I have not completed mandatory period of 18 months from the day when I have passed the first year exams. Whereas because of the COVID-19 situation, my lord, other students were permitted. And I am requesting this honorable court to place me on the same footing, and I should also be permitted, and my result should be declared, which I have already given the exams. And my result should be declared. If I have passed, my lord, I can write my third year examination, which is scheduled in the month of August 2024, my lord. The para number 5, my lord, the COVID-19 situation has been taken into consideration.
That's right. Petition has become infructuous. The reason is this. My lords, kindly see the prayer sought in the writ petition. The prayer sought in the writ petition is that to declare the petitioner to be eligible to prosecute and complete the MBBS course of study in the regular batch, including the appearance in the examination without interruption. That was the prayer sought. He wants to be placed with a regular batch. The regular batch, my lords, they have passed out and they went out of the consult.
Prayer may be bit wider, generally, we can hold it.
No, what had happened is this, my lords.
Only because the regular batch, what is mentioned, doesn't mean that that's the pride of heaven.
No. Now what he wants is that.
Saying that academic year has passed.
No, what had happened was this time. I made a certain form. My lords, the petitioner students was admitted to the college in the year 2018 for first year MBBS course. She has written examination for 7 times. She made a 7 attempt. She could not complete it. And finally, she completed a first year course, that is in the year July 2022. So 2018, she was admitted. She completed her first year on July 2022. Now, what had happened was that in the interim period, she files a writ petition, takes the benefit of interim order, permit to attend the classes for the second year. Now, what the petitioner case is that I have attended the classes, therefore I am being qualified to write second year examination. Now, law on point is this means a course persuaded by a student prior to qualifying the first year cannot be clubbed with the course persuaded by them after having cleared the first year examination. That means if she has attended the class for second year, even before completion of first year, that attendance cannot be counted for the purpose of writing examination for second year. So the qualification, the class which is attended can be counted only if she clears the first year. That is the view which is taken by the learned single judge.
Correct.
Yes.
Now we will assume that.
Yes.
Kindly come to para 3 of the affidavit.
Yes, affidavit, my lords, they have supplied.
You allow.
Yes.
Her classmate.
Correct.
To take up complete the course or not is the question.
The course is that, my lords, now that is where the list is. Now, attending the class is different from qualifying the examination for second year.
Whatever benefit you have given to her,
yes,
that benefit you cannot be denied to the other candidate. Is there a submission?
No, that is
now
not.
In para 3 they have said.
Yes.
Do you mean to say
yes,
the petitioner in WP number 1103 of 2021
yes,
was much different from the placement of the petitioner, the review petitioner here?
My lords, now they have supplied the affidavit copy to me. I'll secure the instruction whether the petitioner's case falls within the case of this writ petition. Now, all that I want to impress upon the court is this. The writ petition was filed to treat them with the regular batch of the students. The regular batch students already written exam, they went out of the college.
That makes no difference, as my lord has already observed.
No, no,
That makes no difference unless you answer this.
Yes.
You cannot discriminate being a statutory body.
Yeah.
Is our view, prima facie view.
Correct.
Now,
Yes.
because of that, we had issued notice and we had called for an affidavit.
Yes.
The student has filed the affidavit now.
Yes.
She says whatever benefit is given to the petitioner named in para 3 of the affidavit.
Yes.
That benefit cannot be denied to me on the principle of parity.
My lords, here, the student has not been failed. What I want to impress upon the court is that, my lords, for qualifying the writing of examination of second year,
At least you have to say whether this is on parity.
my lords, I'll
or
just secure the instruction and come back.
not serve a copy of the.
My lords, they have served me copy.
When?
My lords,
On the-
I have written a letter to the university to give an instructions. My lords, I have filed wakalat also.
Oh, that's
I'll-
all right, but when were you served with the copy
My
of the
lords,
affidavit?
I have sent
University
it
is
to-
here only.
My lords, I need some time. Just
My
give me
lord,
3 days time.
One particular portion of the order, my lord. The court has passed the order with respect of that particular student. I request my lords to kindly take para 5, page number 12, my lord. The order starts at page number 5. The observation of the learned judge, my lord, will be at, is at.
Fortunately.
Yes, my lord. Fortunately, due to COVID-19 pandemic, there was disruption in academic studies of all the students in the country, including the petitioner. Taking note of this emergency-like situation, National Medical Commission issued a notification dated so and so, extending the duration of the MBBS courses by a period of 4 months, allowing the colleges to reopen after the lockdown. Consequent to the NMC extending the duration of the course by the period of 4 months, the petitioners also became eligible to pursue their second year course. The petitioner had filed his petition in the meanwhile, seeking direction to the respondent university and declare that petitioners were eligible to prosecute the second year MBBS course of study in the regular batch admitted to the academic year 2018 and 19. I am also similarly placed, and I have also, and this particular fact has not been taken into consideration in my case, my lord.
My lords, kindly see para number 12. The learned single judge quoted the Supreme Court decision. My lords, Bombay High Court, which is relied upon by the Supreme Court, kindly see para number 12. The Supreme Court construed regulation number 9 and observed that there are 2 requirements for admission to the second DHMS examination. First, there must be a lapse of 1 year between the passing of first DHMS examination and taking second
This
DHMS.
notification was not before us.
Please, my lords.
The
Yes, my lord.
notification
Correct.
of the council
Yes.
dated 12/11/2020 was not before us.
No.
This judgment also was not
Yes,
before
ma'am.
us.
Yes, my lord. I did not place this judgment.
You have
on-
not placed
Yes,
it
ma'am.
before
Even
us.
before the
Now
learned
he is
single
showing.
judge. Yes, my lord.
And therefore, if the very term is extended by the council, how can you say that he has not completed 18 months?
I'm sorry. That's what I want to impress upon my lords. My lords, the term 18 months was reduced to 12 months because of the COVID. Now, what the student is contending is that since I have attended the classes, I am qualified to write a second year examination. That's what the petitioner is saying before this court. What I want to impress upon my court is that qualifying to write an examination, first he should complete first year. After completion of first year, if the students attends the classes, that class can be, the attendance can be taken into consideration. Before completion of the first year, if a student attends the class for second year, that attendance cannot be taken into consideration. That is the view which is taken by the apex court. Kindly see, the word supplementary has been taken note. Kindly see, my lords. I just draw my lord's attention to page 15. Passing of first year DHMS exam, student has to undergo the course of study of 1 year. The Supreme Court observed that if a candidate passes in a supplementary examination, the requirement of 1 year cannot be enforced. Supreme Court deferred to the Oxford Dictionary meaning of the word supplement and observed that adjective supplementary means an examination to make up the deficiency. The Supreme Court observed that it stands to reason that only when the deficiency are made up, the whole become complete. The Supreme Court made it clear that therefore passing supplementary examination would not relate back to the annual examination. What counts is that when a whole is made up and from that time of making up the whole, 1 year and 1.5 years must elapse for the second or third DHMS examination. Next, my lords. In a judgment delivered in WP number so and so, the court was considered the similar question. After considering the relevant decision on point, it was held that 18 months course of studies before a candidate can permit to take the second year MBBS examination must commence to run after the candidate has fully qualified the first year MBBS course examination. It was further held that course persuaded by a students prior to qualifying the first year MBBS personal examination cannot be clubbed with the course persuaded by them after having cleared the first MBBS professional examination so as to compute 18 months mandatory training period before they can be allowed to appear in the second MBBS professional examination.
The extraordinary situation was taken note of by the learned single judge.
My lord, this is a
The regular,
please,
it was
my lord.
not during COVID period. No, it was not.
Correct. My lords is right.
Extraordinary situation warranted extraordinary ways.
My lords, the extraordinary situation was instead of 18 months, it was reduced to 12 months. My lords,
That's not the point. The point is very, what exactly now if a way is to be found out, we'll go to the next step. But before that, where we stand, let's understand that. 5 years later, after his, or rather 4 years later, he passes his first MBBS, then the others. So after 7 attempts, so 22nd in July 2022, he clears it. In the normal process, he would have now 2022 means COVID is past July. So he has to then enter second MBBS only in July 2022. And that's what my lords have upheld in the writ appeal in para 4. My lord has said that only. So that is where he is in a quagmire. And with the passage of time now, where he has reached, even if we take into account and say, okay, that whatever has happened, and then the result can be declared now, because his result of that period has also not been declared.
If you declare that result.
If you declare that result,
Everything will be repeated.
everything will,
Yes, my lord. Will not arise that
yes,
much.
yes.
You
But
declare that at least in sealed cover, you give it to us.
let them,
Everything will
you
be-
declare that result, and then
No, other things may not be necessary. It all depends. If he passes.
Yes, my lord.
If he has passed.
now
again,
what my lords can say with the passage of time,
That's what.
that, but only thing is he
My-
would only be entering third.
he declared
I have already,
also,
my lord.
he has to complete the
To us.
course. My lord, my
Give us to us.
my lord.
Otherwise, whole exercise can be
Yes,
disposed
my
of.
lord,
Wait.
he should complete the course within 4.5 years.
That's all right. If you tell us, if you report that he has failed, rest of the things, petition, review petition can be closed on that ground itself. Because the period is not, tenure of the period is not kept.
And if he's passing, it will have own effect.
Only ineffective order.
My lords, our difficulty is that.
Only thing is that we may need a few clarifications to be made.
My lords, this becomes a precedent.
I have been allowed to pursue third year also, my lord. I am studying
Why
third
I
year
am
also.
pursuing this, my lords, this thing is
No,
that.
Not become a
the
precedent for
precedent,
rest
because
of
a batch of petitions will be filed later. Because my lords, again, students come before the court and they rely upon the
That-
judgments.
Let them bring the
sealed
result.
cover. Yes, everything is before.
In both of the hearing. Studied throughout the years course and appeared in the final MBBS.
No, final.
This is only
Third year.
Second year.
University.
Clearly stated that we will bring the result of the petitioner to apprise the court about the fact and whether petitioner fails.
I'm
or
sorry, my lord.
passes the exam.
Can I request my lord's direction to the university?
Bring the result. Apprise the court about the exam. Whether the petitioner will pass.
Achha.
Two more.
So hearing on applications, seal number 5, so Vasant Kumar HT. I'm the petitioner in this case, my lord.
The orders have been complied, my lord.
No, my lord.
Liberty was reserved.
My lord, your lordships had closed the contempt petition directing me to consider consider the order of mandamus by the learned single judge. We have now, there is a delay on our part. We have now complied with it, my lord. Allotment of site has been approved to the complainant, my lord.
No, no, my lord. May I make on submission? my lord?
What was the complaints?
My lord, the complainant is an owner of a revenue site in Saram Vishweshwara layout. An alternate site was sought, my lords, pursuant to which direction was issued by the learned single judge, directing us to consider the representation. Now the representation has been considered and an allotment of an alternate site has been ordered for.
Allotment
Now-
is also made now.
Allotment now has to be made, my lord. Now, the acquisition section has to take note of the fact whether they had a site in the land which has been acquired. And taking note of that and the directions of this honorable court in Junjamma's case, where the acquisition officer has to pass a formal order saying that whether he is entitled to or not. Now, the acquisition officer pursuant to the representation has verified the records and passed an order saying that he is entitled for an alternate site. Now, for pursuant to that, my lord, a formal allotment now will be made, my lord.
He is entitled to allotment.
He is entitled to an allotment.
That is one stage. It's like passing preliminary decree, then drawing final decree on installment basis.
The,
Consideration has to be fruitful consideration.
please, my lord.
If you have come to conclusion that he is entitled to a site, then how many years you want to allot that site?
No, my lords, another 1 week, the allotment will be done, my lords.
That itself you should have said.
Please, my lordship may kindly see the orders.
He is entitled to allotment of alternate site. But alternate site has to be granted.
That will also be now follow, my lords. That will
He
follow.
does not want order. Citizen wants site so that he can build a house.
I understand, my lords. It will now follow suit, my
What
lords,
order you
naturally.
want?
Sorry, my lords.
He is entitled to allotment.
No, that is.
Lordship may kindly have it 2 weeks later. We'll come with the formal allotment later, my lords. Learned advocate, Mr. So and
May-
so.
make
for
on submission,
respondent, files a memo dated 4/7/24 along with it, produced is the order, public endorsement dated 1/7/24 in which it is inter alia stated that the petitioner is entitled to be allotted the site. Full stop. This cannot be said to be compliance with the directions of learned.
Please, my lord.
Unless the actual allotment of plot is done. Full stop. Learned advocate for the respondents wants to take instructions and seeks time to comply with the
Please, my lord.
order in totality. Stand over to 23rd of.
May I
Publish.
make on submission, my lord? In the year 31/12/2000,
All right, now they
You
have
put
to
an
say.
end to the matter by
We
20.
will do it, my lords.
Yes.
number 6,
Publish, my lord.
grateful.
For complaint, my lord. Your lordship, while disposing the contempt petition, observed that if they don't comply, your lordship, aggravated contempt will be initiated. Despite that, your lordship, they have not restored the revenue entries. This is the matter where learned single judge directed them to restore the revenue entries. Thereafter, I files contempt. Then your lordship, they files an affidavit stating that they'll comply the office objection.
She is filed for a revival of the contempt petition now. The previous time when the contempt was closed, it was directed that they will execute it in 2 weeks' time. I will have to verify why it is not followed.
Your lordship, may kindly see the order passed on the.
The writ appeal was filed, writ appeal also was dismissed. Subsequent to the writ appeal, your lordship,
Sufficient time. Or do you?
some accommodation. your
Call the
lordship.
person, officer, or will comply with
We'll comply,
My lord,
23rd.
23rd. A week's time maybe, 23rd.
23rd is more than a week.
Yes.
They'll have to restore the revenue and there's nothing more, my lord, because it's
So
in the
learned
name of government.
additional government advocate, Mr. Jafar Shah stated that the compliance will be obtained before the next date, stand over to 23rd July.
I'll seek instructions.
Grateful. my lord.
Number seven,
We'll comply.
to Nishan.
Comply. There is a specific direction.
Yes, sir.
Seven,
PM for the complaint. In this, they have to issue a preliminary notification, not by Saturday, they will issue it. Because what has happened is a road is, my lord, has been formed. There is a 2-kilometer road. So, my lord, they have completed the survey. We'll prepare a preliminary notification, final notification, give the compensation. Your lords may call this after, my lord, on the same day, 23rd. By then, my lord, we'll file a
23rd.
preliminary and then. Great.
till number eight.
Again, for the complainant, my lord. Well, I have filed the revival application, my lord. Contempt petition has been disposed of, my lord, taking the accused number 1 submission, my lord, that is, he will complied with within 8 weeks, my lord. After 3 months also is not complied, my lord, hence I have filed the.
Who is opposing you?
Instructions from the client, if you could short accommodation date for the same.
Do it by 23rd, whatever you want to. 23rd.
So number nine.
Lord, the contempt was closed on the last occasion on a submission made by the accused counsel, saying, my lord, the order has been complied with. My lord, the specific order of the learned single judge was to allot the land in favor of the petitioner. Now, the compliance, they say, the so-called compliance is, they have reserved that same area for public road.
Public purpose.
So, in effect, there is no compliance, ma'am.
No, we have made it clear in para 5. It is clarified that if the complainant has any grievance with regard to the decision taken in the order passed, it will be open for the complaint to independent
Yes, my lord,
proceeding.
because I made a submission on that day. What had happened was, my lord, when the matter was called up, that is when the memo was filed before this honorable court. And that copy was also given to me when the matter was called out. That's when I had a reservation as to the contents of that memo. So I made a submission, then my learned court actually passed this order saying that you may. My lord, now the problem is that I already have an order in my favor. Now,
No, for that.
now
contempt
an
proceeding,
effective
not the-
complaint has to be reported, my lord. It cannot be a sham complaint, an effective complaint, just like my,
It's not the question.
my lord just mentioned in the earlier matter also, complaints must be effective.
No, but we have made, in that we said,
There's a
if you
positive.
do not comply with, then aggravated contempt would happen. We have said in so many,
There's
here
a-
it's not that.
No, my lord.
You should go to the details.
Can I make one submission?
Case for mandamus.
Mandamus.
Yes, my lord. And in the mandamus, there's a specific order. It's, my lord, now what has happened is 58 residents are suffering. We don't have an access to the road. And all the neighboring properties, they have been given access by way of a sale of that property. It's just, my lord, what happens is, it's an apartment, residential block, 58 residents are there. My lord, between my land and the road, it seems there is a government land. That is only about just a little more than 1 gunta.
Which were closed by order dated 27th March 24 are sought to be revived on the ground that the site to be allotted, land or site, land.
Small piece of land, yes.
Land to be allotted to the.
That's my
petitioner
access.
Has not been allotted, and that the authority has reserved the plot for common.
Public purposes.
Full stop. The direction of learned single judge was to
Consider.
No, to allot, no consent. Learned single judge said allot.
consider or allot.
Allot, my lord. Page number 19, my lord. Page number 19. Respondent numbers 1 to 3 are directed to act pursuant to the recommendation of respondent number 3 as per his letter dated so and so to the writ petition and grant the land to the petitioner within a period of 3 months. Now, contrary to that, they have reserved it for public road. They have reserved it for public road now.
But the land has been now reserved for the public purpose, Your Lordship.
How?
Then you give other land. It will be
No,
in
the
the
other-
nature of compliance, but this is in nature of.
Violation, breach.
Well,
Because positive direction.
Yes.
Law is very simple, but you must know how to play with it.
And similarly placed,
Technically, they do.
my lord, similarly placed access has been
I'll seek
sold to
instructions.
other neighboring lands also.
Do it. You give some, otherwise you'll be in difficulty. We may dispose it of no difficulty, but still our
Yes, sir.
heart doesn't go with the disposal. Our mind may go.
Yes.
23rd last chance.
Yes.
Otherwise we'll, whatever order we want to pass, we'll pass.
Obligation, grateful.
It may not go in favor of you also, we don't.
My lord, last 12 years,
They're asking.
we don't have an access to the road. We don't have a compound wall, that's the thing. Yes, for a residential building, we don't have a compound wall because of this issue.
But we have not reserved the liberty to, we have not said that you will be, non-compliance will expose them.
Even in his own affidavit of revival that he has filed, your lordship, they
Correct.
have said, we have said land is granted subject that you cannot put up.
Typically,
the-
once we close the proceedings of contempt, the non-compliance thereafter will be a matter of mandamus.
My lord,
Your
there what
lordship-
happened
your
was,
lordship,
no,
the
the
direct-
problem is,
the
already there
direction
will
is-
be a multiplicity of proceedings.
No, no.
I have an order in my favor. I wouldn't want to lose
My
that
lord, the
benefit.
land was reserved for public purpose. Public purpose in sense was for road.
What about the direction to allot?
The specific direction to allot land.
Yes.
Cancel the public person allotting.
The public purpose is road which he is seeking. What we have said was don't put up a compound
Then
because the
tell us-
contention is public can use the road.
Then the order of law on a single judge, that this can't be done because it is reserved for public purpose.
And it is based on their own recommendation. It is based on their own recommendation.
Contempt is arithmetic, 1+1, mathematical, 1+1,
Yes.
or 1 - 1, whatever.
Grateful.
For 10,
I have paid for complaint, my lord. I have filed an application for revival, my lord. It is posted for IA for recalling, my lord. I have not filed the recalling for IA, my lord. IA for recalling, my lord. I have filed
Yes, so
revival
it's not-
application, my lord. It must be posted for revival, hearing on IA, my lord.
File application for delay.
My lord,
There is a delay
for
of
revival, my lord, there is no delay,
office
my
as per the registry. The present application is filed after delay of 42 days.
my lord.
It appears that the separate application for condonation of delay is not
Yes.
filed.
My lord, it's
Same
the
shall be-
revival.
The same may be filed if advised.
Application for revival, my lord.
There is delay.
For revival, my lord, there is no delay comes. my lord.
So after 10 years, you can come
No, my
here.
lord, only 1 month I have, the time for,
Office
time for
you-
complaints, my lord, ended in the May
It
20.
is wrong in filing. You file a formal application and get it listed. On that day itself, we'll condone,
Date, my lord.
23rd.
number 2, my lords. Serial number 61, my lord. Connected matters are posted on 6/8. Should be posted along with that.
No, on all 23rd, then we'll see on. Then not convenient to you, then on that day you mention.
Alright.